It's bigger than you. It's bigger than me. It's bigger than all of us.
Aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case.
Is that correct?
Oh, for Trump's sake. I didn't ask you to interrupt me. Dati mihi Anglican for he's verbal Latino.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. I hope your lunch was as wonderful and delicious as mine. Had a combination of fresh homemade bread and leftover dinner. I'm not sure what it is, but it has like a ravioli with like a pesto stuff inside, and mushrooms and a tomato sauce, whatever that is. I think it's like linguine something. I don't know. It was cold. I didn't even warm it up. Just.
We're ready for Mr. Wolfenbarger, please.
Uh-oh. Are we starting already? I think we're starting already. Let's bring everybody in here. Let the music finish.
That's not mine.
All right, where we are, by the way, as we jump around, we've got court about to begin right now. They're bringing the defendant into court. That's great. We've also got, let's see, this is the Adelson case, which is still developing as they're just coming back from lunch. Let's see, we have Judge Simpson, who I don't think Mr. Magoo...
Break. We had agreed that we would come back a little bit early to discuss what we expect will be the afternoon testimony of the domestic violence expert.
That's correct, Your Honor. I assume she's the next witness, is that right? Or no?
Maybe, no. It'll be Hopdol, I believe. It might be the next one.
Is Hopdol the medical examiner?
No, Hopdol is the
Anthropologist? Yes.
the dentist, the forensic dentist.
Okay, but presumably that will be relatively quick?
It is quick, Judge, just so the court's aware, it is quick, but the defense agreed to allow us to present her via Zoom. There was some issues with her traveling.
Okay.
So I want to send her the Zoom link now.
Okay.
And then we just need to let the court know to let her on when she's ready to go.
Sure.
James will be today. Just stick it in your pocket. That's what we expect.
We believe so, yes.
I'll assume we are making good use of our time then.
Okay.
We talked about this last Monday, I think, in our pretrial motions hearing. The issue is whether Dr. James, Dr. Rosa James, kind of what the scope of her testimony is going to be. She doesn't know any of the facts of this case. I think we all agree with that. She hasn't seen any police reports. She hasn't interviewed any witnesses. You know, she is, I've heard different phrases used, but a witness who has no knowledge of the facts and instead is simply going to educate the jury about, I don't know what, but in general, the behavior of perpetrators and victims of domestic violence. It is my fear that is going to involve hypothetical questions, which will, in effect, serve to educate her about the facts of this case, many of which will be contested, probably, and that it will be, under 403, an improper way of introducing expert testimony. But more importantly, even if it is limited to hypothetical questions, and I don't understand, let me just get to the point, what the bottom line is. What is the final conclusion that the expert's going to say? If she's going to say, it is not uncommon for people to ask for TPOs and then withdraw them. And here's how the cycle of violence, often works. I'm not saying it's true in this case, but this is in fact a phenomenon known to doctors, sociologists, psychologists, whatever. First of all, we've already had the testimony. We just had that from the detective who said, oh, it's not uncommon at all for people to withdraw their TPOs. But fine, if they want to do that one more time, I'm less concerned. I'm not going to say I'm not concerned, but I'm less concerned. What really concerns me is what we got a taste of last Monday when she started talking about the threat of leaving increases the lethality rate by whatever the percentage was. And even more importantly, any suggestion that there is a history of abuse here other than what's in evidence is completely inappropriate. Right? I mean, we can't be having this witness either answering hypothetical questions or talking about the cycle of violence. I mean, if you just look at her chart, it's over and over and over again. You get beaten up, you complain, then you make love. Then you get beaten up again, and you make love, and you complain. There's no evidence of that in this case. And I can't understand why the prosecution should be allowed to put up an expert to pretend it is the evidence in this case. And then to get an opinion that this is common in the field. My basic argument is that under 404B, that's essentially propensity evidence anyways. You're essentially saying he did it in the past and therefore he's guilty of this case. And as we talked about last week, the law on this subject has become crystal clear that the prosecution has to be specific and precise about the reason that the evidence is being offered of prior acts of violence. If it's a self-defense case, it can be offered to prove it's unlikely self-defense because he used the same defense last time. If it's a lack of knowledge case, it wouldn't really be applicable here. If it is a...
Sorry, sir, if you could step outside. Thank you, that's okay. That was the record will reflect that was the witness who's on the stand. I've asked him to step outside.
That's fine. Or even lack of intent. None of those are issues in it. This is a whodunit. This is strictly who committed the crime. And even if they have, by preponderance of the evidence or something that would satisfy, the court that it's at least admissible evidence that there were some prior episodes of, Oh, no, that's okay.
We just didn't know where the noise was coming from. We're all like...
What are you doing?
I lost track, of course, but and that was intentional on the DA's part. I'm
sure he's absolutely messing with you.
The point is, in a case in which the defendant denies doing it at all, the threshold for similarity and for the admissibility of 404B evidence is far higher. As I said the other day, it has to literally be the mark of zero. You can't say that he denied doing it, but by golly, we're going to prove it wasn't self-defense. Nobody's ever said it was self-defense. They can't say, he denies doing it, but by golly, we're going to prove whatever he did with intent. Or, course of conduct, which isn't even an accepted one under the Georgia rules anymore. So they just need to be precise now, ahead of time, instead of making me jump up and down with the jury.
What is that?
Your Honor, I apologize. In preparation to get ready, we were setting up the Bluetooth, but we're done.
Okay, thank you.
They're still doing it.
So, and I think you understand my point. If you're going to use it for identity, you have to show only this person could have perpetrated the crime because of his MO. This is the way he operates. He kills people and then he dismembers them. If they have prior incidents of that, then they can certainly put in evidence of prior dismemberments he's committed in order to prove that he is the most likely candidate for being the perpetrator in this case. But other than that, the fact that he allegedly, and I stress that because I don't even know where the evidence is going to come from at this point, that he allegedly scratched her arm, dragged her down the sidewalk on one occasion, and I mean, there's been inconsistent evidence of there's no other arrests, no other contact with police, no hospitalizations, no doctor's reports, no pictures. There's nothing else other than the one TPO in July of 1998. So I think the DA should be obligated to preview what she plans to do and make sure that it's acceptable to the court.
Okay, thank you, Mr. Samuel. Ms. Hilton.
Yes, Your Honor.
Yes. Thanks for paying attention during class, Miss Hilton.
Thank you, Your Honor. As we discussed last Monday with the testimony of Ms. James, we advised the court that we would be bringing Ms. James up towards the conclusion of the case, or not the conclusion, but towards the end of the case after we believe evidence of violence would be admitted. At this time, Your Honor, the court has not just heard about a July 1998 incident, but the court has heard through the witness Tina Mae Patton about an instance in which she saw her sister come to their job at the Waffle House, that she saw bruises on her sister's neck, that when she asked her sister, either one remembrance is either her sister said it was Chris, or when she asked it was Chris, her sister kind of indicated in some way to confirm that that's who perpetrated that injury on her. We also know that there was a secondary time in which Tina Mae wanted to confront Chris about the abuse he was perpetrating on her sister, and her sister asked her not to approach him in fear of what that may do to him. We also know that there is testimony, and this is the state's position, that this defendant moved her to a community in which she had no familiarity, did not know anyone, which we believe would be a form of isolation. That when they moved to that community, she never spoke to any family, she never spoke to any neighbors, she never spoke to anyone there, so she was pretty much just in the house. I believe Miss Dorothy Jones, or Dorothy Cooley, testified herself that she didn't even know her name, never spoke to her, even though Mr. Wolfenbarger had a relationship or a friendship of such with Miss Cooley, and we believe that is evidence of isolation. We know
it could be evidence of her not being there,
and I think that's an argument that they can have. Additionally, we have evidence that Miss Dorothy Cooley heard arguments in their home, that even though she tried to change her testimony on the stand, what she said at one point in time in her testimony is that she would hear her screaming. She also noticed or saw Miss Wolfenbarger with a black eye under her eye. She was wearing glasses, but she did see markings of black eye. So there is evidence of physical abuse. We know that she also told her mother about the 1998 incident, about the dragging of her. So we know that there is indications of physical abuse. We believe that that information in and of itself shows that there was a pattern of abuse such that Ms. Rosa James could testify as to the domestic violence dynamics. What are certain signs in that pattern and control? And the jury can make a decision whether or not they believe that this is a domestic violence relationship. It is the state's position that this was a domestic violence relationship. We believe that there's evidence to present, whether that is in hypotheticals, to Ms. James about some of the events that occurred in Ms. Wolfenbarger's life leading up to her death. We do believe that she'll be able to testify as an expert in domestic violence that the most dangerous time for a woman is when she attempts to leave that relationship. I believe that there is evidence that Mr. Wolfenbarger, in his own words, will say that in December of 1998 that the two of them were trying to work it out, but I believe her mother testified that she wanted to leave him. I think that testimony came in. I believe so. So there is evidence that she did want to leave him, and such that we think that there is enough information to make Miss James's testimony relevant before this jury, and it is not excluded by Rule 403. That it is more probative, and that the prejudicial effect is not substantially outweighed in this potential case. And so that is the state's intention at this time. We do believe that, again, that there is evidence, whether or not the defense counsel, crosses her on it and talks about isolated incidents and things of that nature. I think they very well can. But we believe that there's enough at this juncture, Your Honor. And that would be the state's intention. I think we discussed last Monday, the state would never ask the ultimate conclusion. Based on all this, did he kill his wife? That would never be a question that the state would ask. But we definitely intend to ask questions about statistics regarding the most lethal time for a victim in an abusive relationship. And so that's the state's position, Your Honor.
Thank you, Ms. Hilton.
I would point out we've not been given any statistics. We've not been given any evidence.
We asked for it a week ago. Sorry.
I mean, if she's going to start talking about 85% of all people who want to leave their family get murdered.
I didn't hear Ms. Hilton say that. What I heard Ms. Hilton say was the very broad, generic statement that I've heard from, I think, every DV expert ever, which is that the most dangerous time, that there are particular times in a domestic violence cycle that are particularly dangerous, one of them being when someone has attempted to leave.
Wow.
I'm not saying that I'm saying it's admissible right now. I'm just saying I didn't hear her talk about statistics.
She used the word statistics. I didn't make it up. She said that she's going to cite statistics. So I don't know if that meant, in general, it's the most common time, or if she's actually going to testify to 87% or whatever.
This sounds off.
The general research, I should say, maybe not statistics, but the general research that the most dangerous time for a victim in an abusive relationship is when they're trying to leave.
Okay.
It sounds like, almost kind of like profile evidence, and it's not the way someone gets convicted of being the perpetrator. It may be a good, as one lawyer described it recently, a good sword for proving, this is the perpetrator. If this is, it was intentional as opposed to accidental, or a way to defeat a claim of self-defense. Say, you've beaten her up 30 times and you're claiming this is self-defense this time, or it was, suicide. You were trying to take the gun away from her. But he's saying he had nothing to do with it. He had nothing to do with the crime. And yet they're going to use this profile evidence of what other people, based on some similarity, I guess. I mean, I know what she's going to do because she did it the other day with me. You go through the wheel and you say, oh, you don't have to have all these things. You have to have a couple or a few or some number of them. And, we get into this argument where everybody's a domestic abuser, under her theory. If you take the wheel out, wherever I did with it, and start going through it, everybody satisfies. You can go through it and say, there was no evidence of this, no evidence of this, no evidence of this, no evidence of that. She says, it doesn't matter.
And that goes to the weight and credibility that a finder of fact should afford to her testimony,
It
assuming that she's allowed to testify.
It is unfair. It is 403. It is the jury's going to hear she's the most qualified person on the planet to be offering these opinions, and we're apparently nitpicking over things that she has studied and the statistics and all that.
Understood, Mr. Samuel. So what I heard from the state is the identification of at least, I think, three instances from which either there is actual testimony of an event like the matter in July that I think led to the TPO, or there are facts from which a reasonable inference for purposes of a preponderance might be drawn that there was some abuse. And so as a result of that, I do believe that the state has made, there are facts that they can ask the expert about. I do want to put one issue to bed, and Mr. Samuel and I discussed it at the pretrial conference last Monday as well, and that is that 404B has been thrown around a little bit, and I think I understand your argument currently to be that it's 403 prejudicial, but the argument that you're making, I still stand by that it is intrinsic to the nature of this relationship, and that is what distinguishes it from this sort of argument that might not fly, that, you know, if Mr. Wolfenbarger, if there was evidence that Mr. Wolfenbarger had abused someone else before, that would exponentially increase the likelihood that he had abused Melissa Wolfenbarger. That's not what we have here. I'm specifically looking at Hughes versus State, which is a 2021 decision of the Supreme Court, talks about similar evidence in terms of an incident where the defendant was alleged to have slashed the tires of the victim, and the defendant ultimately argued that was inadmissible 404, that it was prejudicial, and that it was error to allow it in, and Justice Boggs said it was both intrinsic and evidence of prior difficulties. And so I think it's relevant, I think it's admissible, and under 403, I don't believe that it is overly prejudicial. Now, having said that, I think we talked about this on Monday as well. I don't think that the state intends to go out on that limb, right, and ask the witness questions like, you know, the ultimate issue and other things. But I did hear a concerning willingness by that victim to walk out onto that ledge all by herself. And so I just want to make sure that you have cautioned your witness to understand the parameters of what's allowable for her to testify to.
I have, but I will again prior to her testimony when she gets into the building.
Understood. The remainder, Mr. Samuel, as I said, your other concerns about the scope of her testimony, the veracity, reliability, et cetera, I think goes to, again, the weight and credibility to be given to her testimony. And so that's going to be my ruling regarding to testify and to base hypothetical questions on facts that are actually in evidence regarding 2 to 3 either specific instances or facts from which a jury could infer, a fact finder could infer an abuse.
Can I just ask, let's assume you asked the hypothetical questions. Assume 3 incidents and describe them with specificity and accuracy. What is your conclusion? What are we inviting her to conclude? You are dealing with an abuser. And once we've made that finding, Katie bar to the door. At that point, we can do anything we want to do once we've identified him as an abuser. That's what I'm trying to figure out. Let's assume he did it 3 times. What is she going to conclude? Is it anything you could do? It wouldn't make a difference if it was 3 or 30. At that point, everything I want to offer as an expert, I can offer.
Ms. Hilton? So I think my understanding and Mr. Samuel's understanding clearly is that this expert would be offered to testify about what an abusive relationship looks like, and how people behave in that relationship. Is that fair?
Yes.
To educate the jury about those issues.
Yes.
Beyond that, Mr. Samuel's question about what actual opinions or conclusions do you expect that this expert will draw regarding this case? Or is she just educating the jury generally about what an abuse relationship looks like?
Generally as to what an abuse relationship looks like, and if there are certain hypothetical facts be consistent with coercion or power and control. So
hypothetical facts for which there's a reasonable factual basis in the trial.
Yes.
Okay.
Yes. And so that is the extent, but she's not coming, we're not asking her any, is this domestic violence? It's more if a person brings someone to a neighborhood and they don't have any family there, could that be considered isolation? So things of that nature, factors that one could maybe conclude at some point in time or that we'll be able to discuss, but that's the state's intention.
Mr. Samuel? I understand and imagine that you would not be satisfied with that response.
Well, a few minutes ago is the first time I ever heard there's some theory that part of the whole, maybe as you're describing, intrinsic conduct was moving to Atlanta, to get away from her family, which is what, the other evidence was. But now we're going to have this witness say, oh, if you've moved to Atlanta, to a home that their family owns, right?
Right.
I mean, they own this apartment complex, the duplex.
Which are all facts that you can cross-examine the witness about.
But that's the whole point, is she doesn't know any facts. So I got to take her hypotheticals and say, let me pull a few threads on these hypotheticals. How about if you found out that the home to which she moved, was actually a home owned by the family? And she says, no, it doesn't make any difference.
I understand. My ruling still stands, Mr. Samuel. I'm going to let the witness testify. I think that your concerns relate to the weight and credibility that a fact finder should afford to her testimony, beyond the fact that, as I've said a couple of times now on the record, and Ms. Hilton has assured me, is that, we're going to make sure that our hypothetical questions are tied to the facts in this record, even if they're conflicted facts. As long as they've been established by somebody in this case, number one, and number two, that we're going to make sure that this witness is not expounding in a way that would be problematic in terms of the ultimate issue, or offering opinions that there are no facts to back up, even if they're conflicted facts. Okay?
Yes.
Okay, that's my ruling, Mr. Samuel. Anything else that we need to take up before we have the jury back in to conclude the detective's testimony?
No.
Okay. Ms. Hilton, you ready?
I think
I'm sorry, Mr. Fawcett, are you ready? No, I understand. I just was making sure both sides are ready. Deputy, can you get our witness back, please? And then we're ready for the jury.
All right, so that was a long pre-trial. Let me cut for just a second. I'm going to try to fix the audio. See if that can get the sync fixed up just a little bit. Ms. Hilton, in the middle of the defense making a motion, which the judge asked them to come early to argue in front of her, starts playing at full volume testimony that she hopes to be able to play later in the trial over Bluetooth. She's just testing out the tech to make sure it works. Big oops. Takes a while to turn it off and causes a disruption. Disrupts the thought process and the argument of the defense, which she calls out and says purposeful, and then as a joke, and then continues on. And she does it again, because we're just testing, Your Honor. I know I'm supposed to be making an argument. You asked me to come in here and argue this issue, but we're just testing. And she does it twice. I'm like, oh my goodness. That was bad. That was bad. All right. Yeah, that little argument, it did seem that the defense case resonated with me a little bit on that one. But I'm still on the fence. I'm not saying the judge was wrong in making the decision to allow the witness to testify. I don't like the idea of an expert witness coming in who has no facts of the case, who's going to expound and say, as I'm sitting here in the courtroom, you telling me this happened, thus I can tell you in this case this is what applies. I hope we don't try to go there.
Thank you all. Please be seated.
Jurors are here.
Detective, I'll just remind you that before we took our lunch break, you were sworn in and that you continue to be under oath, okay?
Yes, ma'am.
Thank you. Mr. Samuel, questions for this witness?
Detective Shepard, my name is Don Samuel. I don't believe we've ever met before.
I've met you in passing before.
This is the second one to say that. You joined the cold case squad in 2020, did I get that right?
Approximately, yes.
Okay. And when did you pick up Calhoun's reports and start looking at this case?
2021.
Okay. So in 2021, we are essentially 23 years after for example, the first thing you testified about, I think, was the July TPO, right?
Correct.
Okay. Obviously, you weren't there then. You didn't have, contemporaneous evidence of what happened on that day, right? You didn't interview any of the witnesses.
That's correct.
That led to the TPO, correct? Correct. And when I say TPO, I'm talking about a temporary protective order.
That's correct.
And you introduced some exhibits this morning. Yes, this morning, dealing with that TPO, right?
Yes, that's correct.
Okay. So what you learned from reading Calhoun's reports and what led you to think the TPO was important was that there was an argument, correct? There was a dispute?
Yes, there was a physical dispute that resulted in Melissa Wolfenbarger's injuries.
It resulted in?
Her injuries.
Okay. Did you interview someone named Perone who was involved in that?
No, I never got a chance to interview Ms. Perone.
Okay. And did you talk to the law enforcement officer who went to the scene, whose name is Sutton, I believe?
No, every officer during that time, by the time I received the case, pretty much retired. But I was referring to his actual police reports that were documented.
Well, he came here. It wasn't that hard to find them. He came here and testified. Did you ever talk to him?
No, sir. I never was able to talk to officers.
Were you aware that he said he never saw any bruises on her back?
The only thing I had to refer to is it wasn't the actual police report that he documented when the incident occurred.
Right. Well, he didn't document what he saw. And when he testified, he said, I didn't lift up her shirt or look at anything on her back. I didn't see any. In fact, he said she had some bruises on her legs.
To counsel testifying.
I'm cross-examining him.
Yeah, I'm going to overrule the objection.
I have no direct knowledge to his testimony when he testified in here.
So if, in fact, his testimony is different than what you said this morning, obviously you don't question his credibility when he came here and testified under oath.
I think Officer Sutton will have to be the one to speak on that. As far as his credibility, I can refer to the documents that were documented in the official police report.
Okay. And do you know from the official police report whether the officer or anybody interviewed Mr. Wolfenbarger that night?
Not sure. I don't have any reports that stating that either.
Or Mr. Perone that night?
There are no police reports that's documenting that.
Okay. So you have Sutton's police report, which is inconsistent with the testimony he gave to the jury, and that's it as far as what led to the temporary protective order.
Again, I can't testify to Officer Sutton's testimony that he testified in here. Only thing I have to go by is what he documented in his police report.
Okay. All right. Now, as a result of whatever happened that day in July something like 22nd, right, 1998, Ms. Wolfenbarger was encouraged to take out a TPO, correct?
Yes, after she was assaulted and dragged by Christopher Wolfenbarger and received the injuries. Usually when there's a domestic dispute, we always refer to the victim in that domestic. That's an option that they can go and seek as a temporary protective order for further protection.
Can I ask you to do me a favor?
Yes,
when
sir.
I ask you a question, you can answer yes or no. Okay?
Cool. Okay.
All right?
Yes, sir.
If you think it's a deceptive answer and you need to explain it, that's fine. But, you don't know what happened that night. You just know what's in the police report, right?
Correct. The only thing I know is what's documented in the police report.
Okay. By the way, did you even try to find Officer Sutton?
I have the official police reports that I can refer to, and that's usually what happens. A lot of cold cases, we don't reach out to those the officers that officially responded to the first scene. We go by the police reports.
Okay. So at any rate, it was customary to refer Ms. Wolfenbarger to get a TPO, correct? A temporary protective order.
Yes, sir. Anytime there's a domestic dispute and the victim of that domestic dispute.
Sir, I just asked you a yes/no question. She was referred to get a TPO, correct?
Yes, she was correct.
You want to make a speech every time I ask you a question, or just say yes or no if you can, all right?
Are you asking me, sir?
Not really. So she takes out a TPO on what day?
We have to refer to the actual document again if we want to get the exact date.
Got a little bit spicy there. If he keeps saying refer to the actual
Some of those
document.
are not in evidence in full, you may remember, but
I think.
You have the date that the TPO is taken out.
As soon as I find a TPO, I can give you the exact date.
I think I'd point out as a defense lawyer that you don't have any independent recollection of any of this, do you? Just point it out. You don't remember any of this.
It looks like it was July 2nd, 1998. July 22nd, I'm sorry.
22nd, okay. Correct. And then what a TPO does is, that's just ask the court to set down a hearing, correct?
But TPO is, again, another form of documentation along with the police report where they documented through the court that this person that's filing the TPO needs protection from the person that they're trying to get protection from.
Right. But it has to be followed very quickly by a court hearing, correct?
Well, that depends on the court. Okay. But once it's filed and it's enacted, the person, we have a court hearing, they're served, and at that point they're served with that temporary protective order. They have strict orders not to violate that temporary protective order.
How long did the TPO in this case exist before they went to court for the first time?
Do you have the documents? Okay. It was dismissed on July 29th, 1998.
So about 1 week later. Correct?
According to the documents, that's correct.
You have the rule nisi there?
Yeah, I do.
Okay. Rule nisi is just a Latin term that lawyers use to say, come to court. Right? Show cause, come to court.
Okay.
Right?
I don't speak Latin, but I'm assuming if you're saying that, that's correct.
I appreciate your confidence in me. So they go to court and the TPO is dismissed, correct?
That is correct.
And that doesn't happen without a judge sitting on the bench, correct?
Correct. And usually when it's dismissed, one of the parties are not showing up. Just like when in the court case, when the party doesn't show up, it's dismissed.
But every party's here for this. For the TPO dismissal, everybody's in court.
Okay.
And in fact, were you aware from talking to people that the judge encouraged them to talk to each other? They talked to each other, and then the judge dismissed the TPO.
I'm not surprised in court hearings.
I didn't ask if you were surprised. I asked, are you aware that that's what happened?
I'm not aware.
Well, did you ever interview anybody about what happened in that court proceeding?
It's pertaining to the TPO?
Yes.
No, sir. The TPO is not related. It's not part of my murder investigation. It documents a first form of interaction that documents the domestic violence between Christopher Wolfenbarger and Melissa. As far as a homicide investigation, it's not relevant going to the homicide. So there was no reason for you to follow up for it pertaining to this domestic.
Well, are you saying that all the domestic things involved in July 1998 has nothing to do with the investigation of the homicide?
The July 1998 incident is very critical. It documents and it landmarks a tumultuous relationship between Christopher and Melissa. So it is very important.
You just said it's not relevant. I'm confused between your last two answers. You said you didn't follow up anything about the background of it, anything about what happened in court, anything about any of that, because it's not relevant to the homicide, but then you say it's the landmark most important thing.
That is correct. So when you document an incident domestic, it's documented. It's a homicide investigation. We continue with our homicide investigation. We have reliability when we refer to the police reports, which is official documents. That's documented in time. There's no need for me to follow up on the domestic side because we have it clearly documented in the police reports. My investigation continues from the homicide on.
Okay. You don't disagree, though, that even the documents show that the judge approved the dismissal of the TPO. The judge signs it.
Yeah, these are legal documents, and I definitely approve of it.
Okay. You then talked about having interviewed Mr. Wolfenbarger in, the first time was in 2021, so now we're 23 years later after the TPO. 23 years after the TPO, you interview him on May 5th, and I think we listened to that tape, correct?
Correct.
2021?
Correct.
Okay, so we don't have anything else at this point between then and 2021, right?
As far as that pertains to what?
Your direct contact.
No, that's the first time I came in contact with Chris.
Okay.
That's correct.
And you meet with him, and you talked to him, and you said it was a voluntary meeting, correct?
Yes, it was in his home, in his living room.
Right. So there was no coercion, no handcuffs. You didn't threaten him, but he voluntarily welcomed you in, gave you a seat at the table, sat down, and talked with you.
Correct.
Totally
custodial.
Totally voluntary.
Correct.
Totally cooperative.
Correct.
Okay. And when you were done with that interview, you packed up your tape recorder and you left, correct?
Correct.
Okay. And then you're continuing to review Calhoun's reports during this time, correct?
Correct.
Okay. In that tape that we heard this morning, Mr. Wolfenbarger told you about a rocky relationship that he had. In part, he attributes it, or perhaps in large part, he attributes it to Melissa Wolfenbarger's parents, correct?
I don't know if he attributes the rockiness to the parents, but he did admit to having a rocky relationship. I don't know how he would attribute it to his parents. As
Not his parents.
Her parents. Correct.
Her parents.
Correct.
You don't think he was attributing it to that?
No, I'm pretty sure he was not attributing to that. I did not interpret that as his parents being, or her parents being a reason why they have a rocky relationship. That's solely between those two.
But clearly he didn't get along with her parents.
He stated that. That's correct.
Okay. Well, I mean, that wouldn't come as a surprise, would it?
I'm not surprised if anybody's in a tumultuous, rocky, violent relationship. I haven't seen a couple that's had a good relationship with any parents involved in that.
Well, but you know that's not what I'm talking about here. Here I'm talking about the fact that his in-laws had murdered 5 people. Do you have in-laws? Are you married? Can you imagine your wife's parents killed 5 people, threw them in a river?
Hang on.
To the form of the question, it's improper, Judge. I would ask that the jury be instructed to disregard the form of the question.
I'll withdraw it. But can I withdraw it?
You can withdraw it.
Does it shock you that someone would say they have a rocky relationship with their in-laws, given what you know are the facts of this case?
I've been doing this job almost a quarter century. I talk to murderers and deal with murders on a daily basis. People from murderers' families. That has nothing to do with what they have to do in their relationship. People can't help who they're related to. Their relationship was their relationship, had nothing to do with their parents.
Okay. So you don't find it surprising that he had a difficult time relating to the family, to the parents who had committed 5 murders, thrown them in a river. There was a baby who died in their home and convicted of concealing the death. None of those things.
None of that came out in the form of evidence during the course of this trial. The counsels have interjected things that are not in evidence and asking questions based on things that aren't in fact. I'd ask that the court instruct counsel not to do that.
Mr. Samuel?
I don't think that's accurate.
I think I've heard the 2 things that you specifically referred to. I've heard testimony about them in this trial, so I'm going to overrule your objection. Go ahead.
But your position is,
are you not paying attention?
It's like Tolstoy said, every unhappy family is unhappy in their own way, right? So it's just another unhappy family.
So because Melissa was from this type of family, that gave her permission to be victim of a domestic violence? I don't think so.
That rhetorical question doesn't answer my question.
Again, because she was a victim of her family and their wrongdoings does not give Christopher or anybody a right to place her in an abusive relationship. So
I'm going to ask you to stop the answer because my question had nothing to do with whether Mr. Wolfenbarger had the right to do anything. And he denies doing anything. So your answer to that, you can give a closing argument if you want, tell the lawyers to go home. Otherwise, I'd ask you to answer my questions.
Can you repeat your question, sir?
Yes. His in-laws were serial killers, right? And were throwing family members they were killing, throwing their bodies in the river. Melissa's sister had a baby who died at birth and was thrown in the hamper. And your only answer to me is that doesn't give Chris a right to do something?
Absolutely. Christopher does not have a right to abuse Melissa based off of her family history. That is correct.
What makes you think that he was using that as a right?
I'm just basing this off your argument that you're making right now, sir.
I've never said he had a right to do anything. And as I just said, he denies doing anything.
Are you asking me a question?
When was the next time you interviewed Chris?
I have it documented in my reports.
Well, when's the next time you interviewed him?
Can we refer to my reports, the exact date?
You have your reports up there?
No, sir. These are the exhibits that you left.
Okay. Did you interview him again in February of 2023?
Is that documented in my report?
It's documented in my notes.
As soon as I can confirm it's documented in my report, then...
Yeah, his report.
We have we have a pissing match happening in the courtroom right now. Wow.
Do you know exactly what page this documentation is going to be in my reports?
Detective Shepard, you testified this morning about the different interviews you have. You didn't require counsel to give you page numbers.
Well, if we were going to refer to dates, then I would like that the notes that you took from my case file, if you can give me the exact date so I can refer to it.
I just told you the date was February 2023.
Okay, on my page and my notes, can you give me the page?
Forget it.
Okay.
We'll move to a different topic.
Oh. This does not bode well for
Are
the
you
prosecution.
familiar with the circumstances of Melissa and Chris Wolfenbarger moving to Atlanta?
No, I'm not familiar with that.
Do you know when they moved to Atlanta?
No, sir, I do not.
Do you know where they lived when they moved to Atlanta?
They stayed off of Brookline.
Okay. Do you know who owned that property?
I believe Christopher's mother owned that property.
Okay. And had they been to Atlanta before or in the Atlanta area before that?
I'm not sure.
Okay. And did Melissa end up having a series of jobs working at Waffle House when she was in Atlanta?
Correct.
And had friends, correct?
Correct.
Okay. And you know that from talking to some of the friends, correct? And talking to people at the Waffle House, correct?
Correct. And also, Christopher's statement was that she worked at the Waffle House and had friends at the Waffle House.
Right. And she wasn't isolated in Atlanta, was she?
I'm not going to say isolated, but there was some, according to the reports that documented that they didn't always see her, but they always saw Christopher. She was always...
Who's the they in that sentence?
Some of the witnesses that was interviewed and that's documented in the case file.
Didn't Miss Cooley talk about how they would play all the time? She'd see Chris all the time?
I'm sorry, you say Miss Cooley?
Mm-hmm.
I'm not familiar with a Miss Cooley.
Okay. Did you read Calhoun's reports?
I did.
Did you read them before you came into court here?
Yes, sir, but I'm not familiar with a Miss Cooley.
Okay. How many times did you talk to the folks at the glass company?
In person, I was able to interview them one time.
Okay. And did you determine from talking to Mr. Brock that ultimately Chris was let go because of a car accident involving one of the company's trucks.
Yes, also the saw that he borrowed.
Is that a yes or a no?
Yes, he also borrowed a saw that he never returned.
He borrowed a saw that he never returned.
Those were their words, correct, that he never returned the saw.
Okay. Those weren't your words this morning. Are you aware of that?
Correct. Mr. Brooks, they said that Mr. Brock, thank you, that he borrowed the saw along with some type of violation that he did with the vehicle. They couldn't prove that he stole the saw, but they let him go as a result.
Okay. You talked about talking with Thomas Dixon, right?
That is correct.
Okay. He'd spent, 10 years in prison between the time of 99, 2000 and the time you met with him, right?
Yes, he was in and out of prison. At that time, he was currently getting his life together. So that is correct.
And then you talked about the time of Chris's arrest, right?
Correct. Yes.
And you said that he was not cooperative at the time of his arrest, correct?
That is correct. He hid in the cupboard that he built inside of his home, and it took, I believe, fugitive about 30 minutes or plus to find him.
Yeah.
Atlanta's best.
He had met with Calhoun how many times? Voluntarily meeting with Calhoun?
It's more than one time.
How many times did he meet with Detective Stott, who was here this morning? Voluntarily, either went to his police department or met with him and was fully cooperative with him?
I have no direct knowledge of Detective Stott or his interactions with Christopher.
Okay. You haven't read his reports?
I have no direct knowledge of Detective Stott or his interactions with Christopher.
Okay, but my question was, have you read his reports?
No, and I don't have any firsthand knowledge of his interactions with Christopher.
Okay. What about Calhoun's reports?
Correct. Yes, I have.
And Mr. Wolfenbarger's cooperation with him?
Yes, yes. Spoke with him multiple times. There is one time that he met with Detective Calhoun, and Detective Calhoun advised that he stole a search warrant that he had. He had to go back and get it from Christopher. That was one interaction that he had with Christopher. So I wouldn't categorize or describe his whole interactions as cooperative.
He stole my search warrant.
At the time of his arrest, how many law enforcement officers went to his house?
You have to refer to the fugitive report, and they should have a list of every law enforcement officer that was assisted in that arrest.
Do you know how many people went to the house?
Offhand, I do not know, but usually when you're trying to apprehend a fugitive for murder, there's going to be a great number of law enforcement.
So if Detective O'Hare was in here yesterday or 2 days ago and said there were 30 officers who went to the house, you wouldn't question that, would you?
That sounds about right. And it's always a tactical safe play or a way to apprehend a fugitive that's wanted for murder.
He said most of them were armed with assault weapons.
That sounds about right, correct.
And helmets and gear and flak jackets and all of that, correct?
That is correct.
Yeah. And used a battering ram to get into the... Well, I'm going to ask you, did they use a battering ram to get in?
I have no direct knowledge on how they made entry into the house. From what I do believe, I do understand that his wife, or at the time what was described as wife, answered the door and she lied and said he wasn't there. And then they was able to make entry and find him. I don't have any knowledge of a ram being used.
Okay. But that is inconsistent with all the cooperation he showed you and Calhoun and Stott over the course of 20 years of answering all your questions, meeting with you, coming to your office, correct?
Incorrect. Whenever you're trying to apprehend a fugitive wanted for a violent crime, which is murder, then you're going to go in the most tactical force used, and that's to ensure the safety on both sides of law enforcement and the civilians that we're trying to obtain.
Yeah, I wasn't meaning to say that the officers were doing anything wrong. I was going to say, if he was uncooperative at that time, it was inconsistent with all the cooperation he had shown you and Stott and Calhoun and Kelly anybody else who he'd been interviewed by with over the years.
So based on the way you framed your question, inconsistent mean that he hid in the cupboard, and he did not hide when we went to go talk to him, but he did hide when they arrived for his arrest. That's correct. He did hide when that arrest happened, and he did speak with us in person.
Yeah, and he had voluntarily given pubic hair to Calhoun.
Correct.
He had voluntarily given other hair samples at other times he was requested, correct?
Correct, and also...
my question was just a yes or no. He also gave DNA evidence when requested, correct? Buccal swabs.
That is correct.
He also, there was the luminol was used in his house, correct?
Correct. 3 years after the incident, though, and the house had been remodeled. So
and all those were done in a cooperative manner. Some you had to get a search warrant for, but others he did in a cooperative manner.
So the last incident that you're referring to is the luminol. A search warrant had to be obtained. So I don't know. I don't have any direct knowledge of interaction at that time that Christopher had with the detectives performing that search warrant.
Well, he wasn't even living there when the luminol was given out.
Okay, so that answers the question. He didn't.
And also, during the course of the questioning by Mr. Fawcett here, you repeatedly talked about things that you found important, correct?
Correct.
Okay. Did you find it important that the pubic hair that he gave to the officers and that was tested was not shown to be consistent with what was found in the bags?
All DNA is important, but also I had to keep in mind that this case was older. Also, I got to keep in mind that the condition of the body parts that were found, and also over time, those things fade. So we're going to do it just to check the boxes and make sure we're going to cross our T's and dot our I's. But also in the back of my mind, I do know that the DNA was going to be compromised because it was compromised.
But the pubic hair was analyzed and was found to be not consistent with what was found in the bag.
So the way I remember the report saying it was dissimilar, and also pubic hairs and hairs degrade over time, and that's the way the report read. By the time this particular item was tested, years had passed it. So over time, DNA does degrade, and pubic hairs and DNA items such as that will degrade.
And you know from the other officer who was with you earlier today and sitting outside that he had done DNA from what was found on the bag, and all of that came back negative.
Are you referring to Detective Stein?
Yeah.
Yeah, so Detective Stein and myself, we did work on this case earlier, and he was definitely a big part of collecting that DNA for further testing.
And it came back as not being consistent with Mr. Wolfenbarger's DNA.
That's correct.
Okay. And you know about the paint chips that were found inside the bag that didn't match anything in the house.
That's correct, but also at the time when they did serve the search warrant at the house had been remodeled. That particular area had been remodeled, so it was not going to be uncommon that those paint chips were going to be dissimilar to one another.
Right. So do I gather that all the evidence that exonerates him, that shows that he's not the person who perpetrated the crime, you consider to be insignificant?
That's incorrect. If you're referring to just physical evidence in that manner, no, but you still have other evidence that goes in line and testimonies that go in line with this case.
I'm just asking about the physical evidence. You downplay the significance of all of that, don't you?
Can never downplay physical evidence. Physical evidence is important, but what you have to keep in mind that over time, physical evidence degrades. And this case is a prime example of that.
You know that cadaver dogs were sent out to the house, correct?
Okay, I heard of an incident. I don't have any direct knowledge of cadaver dogs or APD using any cadaver dogs.
Okay. There's no evidence of, first of all, there was no saw found in the house or in the house where he was arrested years later, correct?
No, the only reference to a saw is when Christopher admitted that he was in possession of, or he was accused of being in possession of while he was let go from his job.
Right.
This witness has an agenda. It's not hard to see.
There's no evidence where the dismemberment occurred?
Absolutely. There's no evidence where it could have occurred anywhere.
He takes it down as soon as they're over, James. You have to capture it live, which we do.
When you were questioning Chris in the 2021 that we listened to, you asked him to say who he thought had killed his wife, correct?
I believe we asked him what did he think happened.
Right. And he responded, of course, he initially said the family, correct? Her family, her parents.
Correct. He wanted.
And then he said, he then said, but listen, I'm just speculating, correct?
Well, we have to go in order. If to answer the question, he pointed all the blame to the father and the family. And what he's referring to when he's saying speculating, he's speculating on different parts of the interview and different parts of the statement that he made.
Yeah. One second, Your Honor.
Sure.
All right. We're on day 4 of travesty of justice. I mean, this trial. Excuse me. And it's getting crazy.
Detective Shepard, you were testifying as to the collection of DNA and the degradation of DNA over time. You recall that?
Yes, sir.
All right. Now, did you have an opportunity to view the conditions of that the remains of Melissa Wolfenbarger were located in?
Yes, I did.
And photographs and the actual scene itself?
Yes, I did.
And did you receive any indication in your reports of any weather conditions that would have existed during around the time that her remains were discovered?
Yes, there was a heavy downpour, a lot of rain in the area.
And is there, in your investigation, have you worked cases where you've been able to successfully collect the presence of DNA?
It's a crap shot. Sometimes I may not. In this particular case, when the particular items that we're referring to that get the DNA when it's compromised, like her body parts was in, like you might as well say, like a soup in those bags, definitely know they're going to be compromised.
You say like a soup. What do you mean by that?
So when it's in a plastic bag, there's a lot of rain. It was in a junkyard. It's a lot of areas, so it's a lot of other things that can come into contact with her remains and compromise, along with a natural weather event like rain.
And we're talking about the time period of April through June. Is that a period of time you would consider to be a particularly hot or particularly cold period of time?
That's a area time of the year that when the seasons are changing, we usually get a lot of rain. In Georgia and Atlanta, that's the time when the weather started changing, the trees started blooming. So yes, we're going to get a lot of rain during that time.
All right. And also heat, does that have an impact on the ability to collect DNA samples?
It does. But that's not going to stop us from trying to collect them.
All right. Now, you testified as to information you received specifically as it relates to any FBI determinations as to the quality or degradation of hair that you would have that would have been in connection with this case. Do you recall when those reports would have been created?
Yes, I have it documented in the report. I believe her name was Dr. Cornsberry.
Okay. And did you have a copy of Dr. Cornsberry's report in your in Discovery?
Yes.
Do you recall that date offhand?
Not offhand, no, I do not.
If you were to review a copy of her report, would that refresh your recollection as to that report?
Yes, it will.
You can review that to yourself.
Yes.
All right. After having reviewed that, does your recollection refresh us to the date of the report?
Sorry. Yes, the data report is October 30th, 2007.
Okay. And is that when the police department received information about the quality of samples that you were going to either make a decision about further testing?
Correct.
And based on the information about the quality of the hair sample, was it either Calhoun's decision or your decision to send off for additional testing based off the information that you received?
Detective Calhoun's.
Okay. But ultimately, when you reviewed the case, you decided your decision was the same as Calhoun. Is that safe to say?
Correct.
And in connection with your interview of the defendant in 2021, had you previously either spoken to Detective Calhoun and or viewed any statements that the defendant made with Calhoun?
Yes.
And were those statements important for comparing and contrasting any similarities and differences between those two statements?
Yes.
And if you found, I guess, things that you viewed as being dissimilar, would that have been significant in your investigation?
Yes.
In particular, questions related to when the last time would have been that Christopher Wolfenbarger would have observed Melissa alive. Specifically that question. You recall asking the defendant that question in 21?
Yes. It gave conflicting answers. One answer was that he dropped her off and she just walked away. The next time he said that they went to Taco Bell and then he dropped her at a train station.
Okay. And I want to refer you to a previously admitted exhibit. I believe it's 73. Okay. Your Honor, with the court's permission, this exhibit 73, which has been tendered into evidence, I'd ask the court's permission to play portions 2420 through 29. Can you tell me what 73 is? It is the interview with Detective Stott.
Are we playing another crappy recording?
60%. Connected to DHCP-L540039F10.
Hang on just 1 second. Can you come here?
Just like, let's, everyone pull the clown car over for a minute. We need to talk. What are we playing and why? This is the Bluetooth recording. What it is I think they have a recording that they've found a way to connect via Bluetooth to play in court, but I think it's an older media. So it's going to be a Bluetooth transmitter to the court system. That's my idea of how this is going on based on what they've said. Bluetooth, yes. Do we know what the train station is? What's the train station?
I can't even say the year she disappeared. I've been sitting there, I don't know if it's 98, 99. I had 2000, I was living in Savannah, so it can't be 2000. But whatever year that they're saying that they've seen her, I know I've seen her like in early March or April of the next year. And that was the last time I've seen her.
That's November of 98 is what they're saying. That's Thanksgiving.
Right.
And then so end of the next year, 99, early 99, March, April, somewhere there is what you think you ran into her. And he probably won't familiar with the area that I am, but so that was she was walking from like the Martin train station up from Brookline. Is that right? right there on Lee Street. And y'all went to a Taco Bell in the area, there and talked a little bit, and what happened? You walk off the other way, or?
I dropped off at the train station.
Yes, you were driving. What kind of vehicle you had?
I had I want to say it's a tan colored Chevy Capri, like a brown color. I mean, I can't be certain of that because I've had gotten off of many cars, but I believe that's what I dropped at the time.
You drove off the train station?
Shortly after there, I went to live with my cousin in Union City.
The house over on Woodline, was that a rental property? I mean, y'all rented that, or you did? You were
My grandparents owned that one, the one across the street.
staying with the entire time that you were there? And you know when you moved out?
I was still living there until March. I was still living there. I don't know how long after that.
Where do you go from there?
To my cousin's house in Union City.
Is there anybody that heard of anything, that's seen her following that or even around that time that I can talk to? Do you know anybody that saw Melissa around March or April, either after you saw her, that you heard back through the grapevine, or before then? That saw her like a week before you saw her or something like that?
I know the guy that used to live right next door to me. He used to work for Marta. He kept trying to go down to downtown. And right around that time, he had told me that he had seen her. He got off at 5 Point Station downtown, and he got off and she kept going straight. I remember telling me that.
The alien noises during this make it hard to hear what's being said. But the UFO is landing, I think.
You said back before when she was up at the Waffle House in Florida that she was involved with some guy named Mike. Remember that? Right. Was Mike an employee over there? Yeah. You know if they were living together or seeing each other?
That's what I was told. That's what she told me. And they had a friend, I can't remember the other friend that I talked to, because their friend actually called me, when we were going to take her back from up there out of that situation.
They said at one point that she was possibly staying at the Shower Lodge.
Yeah, that's where her friend was at. They tried to call her. I went up there and I picked her up from there one night. But she apparently, I don't know if she was in love with this guy or what what too much about it.
Did you know his last name was?
I didn't even know the first thing I said. I can't remember.
White guy?
That sounds right, yeah. I remember he had curly hair. Hey, now I'm trying to be rude, but I got to go back to real bad. If I go pee.
Now, we've concluded the tape.
2856.
2856. All right. Now, Detective Shepard, do you recall in your interview with the defendant, we've just listened to a portion of the interview with Detective Stott and Detective Calhoun. Did you get an opportunity to listen to that as the jury was playing it?
Yes, sir, I did.
Okay.
I did.
And do you recall in the interview that we just listened to, did you hear the portion of the interview when the defendant indicates last time being March or April that he saw Melissa Wolfenbarger?
Yes.
And that was the next year, which appears it would have been 1999. You recall that?
Yes.
And is that also the same time period where Melissa's remains were discovered?
Yes.
And is there anything different about the time period, March or April of 1999, where the defendant indicates he saw Melissa Wolfenbarger, and the time when he told you in 2021?
The exact date, do you have a report that I can refer to? The exact date did he?
I believe you have your reports up there with you.
Yeah, so,
Hey, James, hit me up on this. I can give you some advice on how to do it.
it was May 5th, 2021, when me and Sergeant Layton interviewed Christopher.
Okay. All right. Do you recall the defendant indicating that the last time he saw Miss Melissa Wolfenbarger would have been in December of '98?
Yes.
Do you recall that?
Yes.
Judge has a fan.
Did that distinction between the December 1998 date that the defendant gave you and the March '99 date that the defendant gave Calhoun, was that something you factored into your investigation?
Yes, it was definitely a red flag.
Was that something you considered inconsistent?
Correct.
Your testimony, you were just testifying as to the cooperation of this defendant. You referenced an obstruction of a search warrant. Is that correct?
Correct. Regarding to Detective Calhoun?
Yes.
Yes.
And do you recall what the nature of what law enforcement or Detective Calhoun was attempting to retrieve with that search warrant?
Some DNA.
Okay. And your testimony is that there was an obstruction charge related to destroying that search warrant. Is that correct?
Yes, he stole a search warrant and then destroyed it.
You also testified as to the level of cooperation when you arrived at the defendant's residence when law enforcement arrived to effect the arrest warrant. I believe you testified that the female was dishonest about his whereabouts when law enforcement arrived. Is that also correct?
That is correct.
And did you ultimately find the defendant at the residence where that female was dishonest?
Yes, they found him in a makeshift hole in the wall that he had behind an appliance.
And you were also testifying as to the protective order and the request for dismissal. Did it come up in your investigation that on that July 29th date, Melissa Wolfenbarger's children went back with the defendant's mother, Kathy Wolfenbarger?
Yes, and around that same time frame, correct.
Did you factor in, during your course of investigation, did you also know that Kathy Wolfenbarger had custody of Melissa Wolfenbarger's children?
Yes.
And did that factor into any consideration you had as to Melissa's ability to leave the relationship?
It did, and it factored in a great deal.
What do you mean by that?
So it's pretty odd that a mother would give up her children, but it also makes it really hard in the domestic situation, a violent, tumultuous domestic situation, for them to leave when the person that's responsible for that domestic abuse parent is in charge of your children.
Okay. That's all I have, Judge.
Thank you, Mr. Samuel.
Yeah.
Something when you just began
The redirect examination here about the weather when the skull was found.
Correct.
What was the weather that you think it was?
There were reports of the weather inside the case file. During that time frame when she went missing, in that time frame, the first body part was discovered, which is her head. There was rain.
How did you just describe that rain to Mr. Fossett?
Well, there was a downpour multiple times during that time period.
Okay, can I show you Mr. Calhoun's report?
Sure. Intermittent mist.
Intermittent mist?
Overcast, correct.
Heavy downpour.
Intermittent mist?
Intermittent mist.
Is the same as a downpour?
So as we know, when it rains, it's not constantly raining
When it rains,
as a
it
downpour constantly, unless it's some type of hurricane or something like that in the area. I don't recall a hurricane or anything like that type of weather event at the time that report was made, so it's not unusual for it to be misting at that time, especially after a rain.
But you weren't there. You're just going by Calhoun's reports, right?
Correct.
So you're answering Mr. Fawcett's question saying it was a downpour, but all you have is Calhoun's report that said it was misting.
Correct. As homicide detectives, that's why reports are very important. They document the incident. That's all we have to go on. Like a police report is a legal document, and we refer to those documents.
Can I approach?
Yes.
You
don't have to ask again.
The National Climate Center reports about rainfall.
Okay.
How much rain was there in April of that year?
I'm not a meteorologist, and I don't feel comfortable interpreting this weather report.
Your Honor, I'd like to tender this as evidence.
Mr. Fawcett?
No objection.
What is going to be the exhibit designation?
What number are we up to?
7, 10.
D10. D10 is admitted.
Defense is like, you said downpour?
Thank you.
Defense is scoring big points on this one.
The right-hand column is the total rainfall for the month. For the month, what was the total rainfall in April?
Can you point to the item that you have circled?
Is the total.
That's what you're saying? Okay, the item that you have.
No. For that day. For that day, sorry.
Okay. Item that you have circled is 0.27. What type of measurement is this, though? Is this in inches, millimeters? That's why I don't feel comfortable with trying to interpret this.
I guess what I'm trying to ask is, what made you tell ADA Fawcett that it was a downpour, when in fact you have no evidence to support that, the scientific evidence doesn't support it, and Calhoun's report doesn't support it?
Based off the documentation from the reports and interviewing and talking to Detective Calhoun, that's the information that I gathered.
Well, we just showed you the report. It said it was misting. Didn't say anything about a downpour.
The report is missed, and that's what Detective Calhoun documented in his report, with actually being present on the scene. But those 3 months, there's not a documentation of that. So in those 3 months, I don't think there was a drought during those 3 months. So it definitely rained, but he documented a misting on the crime scene.
So if we bring Calhoun back, he's going to reaffirm what he told you that it downpours that month?
If you bring Detective Calhoun back, I can't speak on what he's going to say. We can only go off the reports and things that are documented.
Never going to this
The
county.
difference in time between these inconsistent statements by Mr. Wolfenbarger about the last time he saw Melissa was how many years?
23.
Which incident are you referring to?
What you just answered, Mr. Fawcett, on redirect.
Can you be specific, please?
There were 2 different interviews he gave. You said it was significant that they were inconsistent about the last time he saw Ms. Wolfenbarger.
Okay, so the first interview was when Detective Calhoun came in contact with the case in 2003. I interviewed Christopher in 2021.
So over the course of 18 years, the first time he said it was the end of 99, correct? The end of 98. And when he talked to you, he said it's the other way around. When he talked the first time, he said it was March or April of 98. And with you, he said let me start over.
Yeah, this is important.
He said it was March or April of 99 when he talked to the first officer, and he said it was the end of 98 when he talked to you, correct?
Correct, but truth is going to be consistent. It doesn't matter how much time passed. If you're telling the truth, that's going to be consistent.
Okay.
So when we hear inconsistencies, that's a red flag.
Like the weather?
Only lies become inconsistent. Truth stays consistent no matter when it's told.
Like the weather?
Even with an 18-year memory lapse between the two.
Absolutely.
You remember where you were 18 years ago?
I do.
On this date 18 years ago?
Not on this specific day, but on this specific year and this month, I do. I can't tell you exactly where I was.
Okay. All right. And were the same questions asked of him about location on those two different events, two different times?
Yeah, I retweeted this out with the video for that one, Regina, on X. If you want to see that, I don't know the outcome yet.
The first time when it was Stott who was interviewing him, correct?
I'm not sure.
Okay. And did he say what street he remembered last seeing her? He was asked about the last time you saw him on.
Are you referring to the statement that he made to Detective Stott?
Yes.
All right, we replay it? I'm not familiar with the interview with Detective Stott.
Do you know today, sitting here, whether the two statements asked him the last time he saw her at the same location as opposed to at different locations?
I have no direct knowledge to Detective Stott. I haven't spoken with Detective Stott. The detective that was primary had this case before me is Detective Calhoun.
Okay, but just a minute ago, for ADF Rosette, you said the two inconsistencies were dramatically important to you.
Yes, every inconsistency is important, especially during a homicide investigation.
But if the two questions are different, then they're not inconsistent, right?
That's incorrect. You can ask a question in many different ways, and the truth is going to stay the same. We find consistency. That's what we do as detectives, as homicide detectives. We talk to all type of people that lies all the time. There's one thing that's going to be consistent is the truth. So we look for consistency. When there's inconsistency, there's lies.
Okay. So if the first time he's asked, when's the last time you saw her on Lee Street, and the second time, when's the last time you saw her on a different street, if it's different times, you'd say that's an inconsistency.
I would say if it's the truth, it will be consistent.
So when you testified previously that it was downpours and then you testified that it was misting, would that make you a liar, sir? Asking for a friend.
Thank you. Mr. Fossett, anything else for this witness?
No, Your Honor.
Okay. Thank you, sir. You may step down.
Yes, ma'am. Thank you.
Have a good day.
You too.
State may call its next witness.
Your Honor, we asked to call Dr. Hoppel, but I think we need to have her patch into the Zoom.
That look.
Has she already done so?
Oh, my goodness. Did you see that?
No, we have to let her in, but has she already attempted?
Okay, I think we had told her to stay. All right, so.
Well, she wouldn't be able to because we won't let her in, but that's okay. Ladies and gentlemen, we have some technical stuff we have to take care of for just a minute, so I'm going to excuse you to just grab a quick cup of coffee or whatever, just hopefully for about 5 minutes or so, and we'll get you back in here as quick as we can.
Let's see if we can replay that. Oh my goodness, let me wake up the rewind machine. I am embarrassed for Fulton County prosecutors. It is embarrassing to see what they're doing here. It's embarrassing to the justice system. If I was a judge, I would be offended.
Let's see, all right, what is that?
The jury's clear. I apologize. I didn't realize that she was the immediate next witness. I would have been more clear to tell her to go ahead and log into the Zoom because she would have just stayed in the waiting room until my staff let her in. But now we know.
All right. Pull up the Wayback Machine on my computer. Let's see if we can bring you this last look from this witness.
Mr. Wolfenbarger.
Yes, absolutely.
Say step out, but I think you know what I mean.
To take a
comfort break. Okay, I'm just getting it lined up here so you can see everything that we can see. And we'll go full screen on this one. Okay, watch this very carefully here. We're going to watch as the witness gets up from the stand. Look at this look right here. The smirk. The snark. And the look back at the jury. Oh my goodness. The swagger. The swagger. Wow. Wow. The arrogance of the witness was disgusting. I agree. It came off quite clear. Here's the problem. People like that jeopardize investigations. If you can't testify in a clear and impartial manner as to the facts as they were documented during the case, you're going to put off jury members. You're going to jeopardize convictions because you have to be the guy with the biggest Waffle House. I don't know what to say there. Now he's a meteorologist. And then when he's confronted when he makes a mistake, exactly. That's why we use these reports. It's like, you didn't. You made it up. You fabricated it out of whole cloth. Exactly. That's why we use these reports. Oh, my goodness. Oh, apparently the view from his Waffle House is much better from the view from any other roof of any other Waffle House. So that's where it goes. The fact he swaggered out. Oh, man. Waffle House will never be the same again. You want me to do ASMR? Oh, man. I could try it. I have to turn the gain way high like this so you could hear every breath. And I won't do that to you guys. He swagered out. He had the swager as if he was in Key West. Key West swager. Never been to Waffle House. Now I won't even try it. I would just say it's not that bad. I would just say don't get the rooftop view. Don't get the table with the view. Just take your order and go, and then roll the dice. Have good medical insurance if needed, and give it a shot. Everyone needs that sort of experience once. Do you hide in the wall behind an appliance? I pretty much am hiding in the wall behind all these appliances. Let's see. There is, you bring up a good point, Joanne. You bring up a good point. There is like a consciousness of guilt factor at play here that is present, where you say, you know, I hate even saying this argument because I have so many issues with it. Well, you wouldn't hide if you didn't have anything to hide, right? You wouldn't be acting guilty if you weren't guilty. No, that's not it. I am scared to death of Fulton County. I've done nothing in Fulton County that would justify the police doing anything to me. It scares me to death. I would still hide from law enforcement in Fulton County to fly under the radar so that I don't accidentally get picked up by them because they scare me. It's possible that living in Fulton County, Mr. Christopher Wolfenbarger felt that same sentiment to a greater degree and wanted to hide. Let's see. I hear Jackson, Mississippi Waffle Houses are great. They suck where I'm at. They did bust them laundering money, though, so I know it's clean. At least the change is clean. Oh, man. Weebug, I did. If you follow me on Twitter, you'll see I tweeted out that video just about an hour ago. about the explosion in the veterinary hospital after a car crashed into it. I don't know what injuries were sustained, if there were any. But from the explosion, it's pretty bad. Runkle and Rob, they're with me, okay? Two respectable lawyers from two different countries agree with me. Stay out of Fulton County. All right. Tammy says, I like their waffles so much I created my own recipe to copy it, and it's so much better. I have never been back. There is something about a freshly cooked waffle. I mean, like just the hot off the grill. Waffles and pancakes are some of those things that just they are so much better fresh. And by fresh, we're talking in seconds make the difference. That's the key, I think. Waffle House doing it fresh. Do you remember the trial where the defendant was half naked and unalived people in a Waffle House? Oh, man, which was that? Did we cover that? Sounds like something we might have covered. I'm keeping an eye on Judge Simpson, for those of you who are asking and curious. He's still working.
Did you call out that you were pursuing him? Did anyone come to help?
He's got an officer on the stand right now.
Unbeknownst to me at the time, yes, there was an Islamic sergeant behind me.
Yeah, anyway, we'll follow that. We will capture Magoo if he shows up. That was the Nashville shooting. Allison says, can anyone in chat help me get a new job? I can't live like this anymore. Allison, what are you interested in? I don't know if there's somebody in chat who's hiring, but drop a little bit of information about what you're looking for. You might have somebody who could help. Waffles are good, but French toast is where it is at for me. Tisha, definitely. Thanks for sharing your sentiment. Thoughts and prayers for you and your mom. IHOP's better than Waffle House. Ivan says, change my mind. I'm not going to. I like IHOP. IHOP is all about what goes on top of the pancakes or the waffles, where Waffle House is more about the pancake or the waffle. That's how they're a little different. I went out to IHOP one time with a friend of mine who was dying from cancer, and she knew it, and it was against doctor's orders and everything, and she said, I just want to go to Waffle House. I just, and she knew she wasn't saying it to anyone, that she knew that she was on limited time. And I took her to Waffle House, and she got what she wanted, and it was really cool. But not Waffle House. I took her to the IHOP. Sorry, I said Waffle House. IHOP has a special place in my mind for that. So it was a work friend. Josh, have you eaten on the roof of the Waffle House? No, I don't recommend it. It's sad, but it was a happy memory.
Jurors are present and counted for you, Honor.
Thank you all. Please be seated. Mr. Wilson, the state may call its next witness.
Thank you. State would call Dr. Mary Beth Hopful.
Okay, thank you.
All right,
so, ladies and gentlemen, you may have seen on the screen as you were coming in that Dr. Hopful is on. She's testifying by Zoom. She's on the screen. The parties have agreed for her to testify by Zoom, and I'm just going to instruct you that you should evaluate her testimony the same as you would a witness who was physically here in person. Deputy, sorry, will you please come back and swear Dr. Hopful? Thank you.
Where are you going to stand?
Oh, man. If you stand at the podium, she can.
Cut courtroom 4B. 4B. Let's
raise your right hand, please.
Okay, I'm cutting.
Do you swear or affirm to the
Showing the
testimony
jurors.
that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state and spell your full name for the court, please.
My name is Dr. Mary Beth Hauptle, Hauptle.
Thank you, ma'am. You may lower your hand. Mr. Wilson, go ahead.
Thank you. Dr. Hauptle, can you hear me fine?
Yes.
Dr. Hauptle, what state do you live in now?
We're going to sit
I
here
live
and
in
watch you.
Florida.
Okay. And what do you do for a living?
Well, I am retired from the field of medical legal death investigation.
No video showing the
as
jury.
well as forensic odontology.
Okay. When did you retire?
I retired in October of 1996.
And prior to that date, where did you work?
Where did I work?
Yes, ma'am.
I worked for the Fulton County Medical Examiner's Office in downtown Atlanta.
And what was your job there?
My job, I wore two hats. My job in this case was as the medical legal investigator. I took the telephone call that came in from the police department on the finding of remains. But I am also a forensic dentist.
Okay.
Working at the Fulton, yes.
Now, your first job, well, your first hat is as an investigator. Could you please tell the jury what you would typically do as an investigator, how you receive some training on that, and how long have you been doing that for?
Well, I had pretty significant training in medical legal death investigation from the people in St. Louis and some people in Washington, D.C. And so I was trained that I am, as an investigator, the person who goes to the scene and evaluates the circumstances, evaluates the decedent, and takes pictures for the purpose of serving as or for the medical examiner in the case. I have to write up a report of my findings, and it's to the medical examiner that I write up what I find.
Okay. And how many years experience did you have at that?
This is the third guy on the prosecution table.
At the time of this case, this was what, in 99?
Yes.
Okay, I was trained, let's see. I received my training prior to being hired at the Fulton County Medical Examiner's Office, and that was in October of 1996.
You received my training before I got hired.
And you also said you wore a different hat as a forensic dentist. Is there a name for your specialty?
Yes, I'm a forensic dentist. I'm the girl they call in when perhaps the DNA in the case is not of good enough quality to do a comparison check, or if the decedent doesn't have fingerprints, so they're not in any system to understand who they are. So they call in a forensic dentist because teeth can withstand all kinds of conditions. They can outlast fire, and they're just impervious to the elements. So my job is to examine the remains, take x-rays of the remains, and then to compare those x-rays to x-rays of whomever law enforcement thinks the person might be.
How does one get to be trained to be a forensic? Is there a special name for your special dentistry? Odontology?
It's forensic odontology. And I took numerous courses from 1991, 1992, 1993. I'm a dentist. I have been a dentist since 1984, but I was a hygienist before I became a dentist. So I've been looking at a lot of mouths and a lot of x-rays.
So you've been a dentist since you graduated from dental school in 1984?
Yeah.
Where from?
From Loyola University in Chicago.
And when you graduate from dentist, does that mean you're automatically a dentist?
No, you have to pass a national board exam.
And
so, though the DDS part, Doctor of Dental Surgery, is the diploma I received from Loyola, we all had to pass this national board exam, and if you didn't pass the exam, you waited around till the next time it was given, and you took it then in hopes that you passed it.
Did you pass that exam?
Yes.
And that's how you became a licensed dentist?
That's right.
Now, at that time, were you just a general dentist?
Yeah.
Did you?
Wilson, forgive me for interrupting, but if you could come here, please, and Mr. McDermott, or Ms. Hilton is on the way.
Judge calls a huddle mid-questioning. Says, bring everyone over here. We need to talk. This might be about the jury being shown. Might be time for a break, too.
Sorry.
Oh.
Go ahead, Mr. Wilson.
Thank you, Your Honor. You said that you were a specialist in forensic odontology. Well, how does one get to be a forensic odontologist?
The way to do this is I was fortunate. Faculty members of mine, both for dental hygiene school and dental school, trained at Walter Reed Medical Institution in forensic dentistry. So you have to take lots of weeks of courses, mostly in pathology, mostly in radiology.
And what is your main purpose as a forensic odontologist?
My main purpose is to identify individuals who are visually not recognizable. So if somebody's burned beyond recognition or skeletal remains are found in the woods, that's the time you have to call a forensic dentist.
And how is it that is a unique field that you can help in? Well, I mean, what are you looking for when you're trying to identify someone?
I'm looking to find that the x-rays that I've taken of the decedent, if they compare identically with the x-rays of the person before they died, then there's no question that this is who I think they are. So it's a matter of comparing before death radiographs to after death radiographs.
And how many times have you done that in your career?
Oh my. I don't know that I'd be able to answer that accurately. It's in the hundreds.
Hundreds?
Yeah.
And do you go through a specialty type exam to become a forensic odontologist?
No, it's the courses taken that matter. And then I also became a member of the American Academy of Forensic Sciences and the American Society of Forensic Odontology, and that's where you get together with fellows, your peers. So I can learn from a case that happened in 1979 when faculty members identified the dead from a major air crash at O'Hare International Airport. I knew how they had done it, and when I realized you could do that, because I love mystery so much, I knew that that was a field for me.
Ma'am, have you ever been declared as an expert in the field of forensic odontology?
Yes, I've testified numerous times.
Have you ever been declared in Fulton County, Georgia as an expert in forensic odontology?
Say that again?
Have you been declared as an expert in the field of forensic odontology in Fulton County? To testify?
Yes. Mm-hmm.
Your Honor, at this time I would tender Dr. Hoptel as an expert in the field of forensic odontology.
No objection.
Go ahead.
Thank you. Are you familiar with the case of Melissa Wolfenbarger?
Yes, I am.
How did you first learn of this case?
I actually am the one who took the phone call from the police that had arrived on scene and informed me that there were remains of a human being's skull or head had been found by the side of the road. So I took the phone call, and then I grabbed the medical examiner, and we both went to the site.
Okay, do you remember what date that was?
Say that again?
Do you remember what date that was? When was that?
Oh, well, I don't remember when it was. It was 1999 at some point. I don't remember the exact date.
And you said the medical examiner accompanied you?
Yes, this was in 1998, and it was Dr. Robert Parker was the medical examiner. So we both drove to where the remains had been found.
Did Dr. Parker regularly accompany you to crime scenes?
Only if I asked him, yes.
Okay. Who else was with you other than Dr. Parker?
Say this again?
Who else was with you other than Dr. Parker?
Well, the Atlanta Police Department, their whole crime scene unit, and members of the GBI were there. Investigators were there also because they were interested. This head that had been found might be associated with a case they were investigating from Twiggs County, where they had, I think they had a corpse and they did not have the decedent's head. So they were really hoping that this would be the head that belonged to their torso, so to speak. So there were a lot of investigators there, not just myself and Dr. Parker.
What was the first thing you did when you arrived at the scene?
I examined the area, I examined where the head was, and then I took pictures myself.
And can you describe that scene when you first walked up to it? What did you see?
What I saw was, and this is badly decomposed, so you have to pardon me because it's out of sort, so to speak, but this, and therefore I knew it had been in a black bag before it had rolled out or been brought out by a German Shepherd dog. It looked like a head with its neck down on the street.
Did you see the fence? Just look at each other.
And it was very deep green color.
What did that mean to you?
Did you just say German Shepherd dog?
Say it again.
What did that coloration mean to you?
Oh, I knew that it had actually been cooking in this bag because the bag was plastic and black. So I knew this was not recent. This didn't happen last night.
Objection. She has been well, can we approach?
Sure.
Sure.
She said German Shepherd. She listed the breed of dog that dragged this bag out. Now I just have to ask the question, how do you know the breed of the dog? Was it Chloe? No, if you know the breed of the dog, how did you find out? Did you see a video? And if so, where is that video now? Or do you have the copy? Are you the one who has the video? The objection that he started to say was she's been tendered as an expert in forensic odontology, and now she's talking about how long the remains have been inside a bag, which is a different specialty, not dental related. I think they still might be able to get this testimony in, but possibly lay more foundation first. Wonder if she saw the video before it went missing.
The objection is overruled. Go ahead, Mr. Wilson.
Dr. Hopto, could you see what condition was the skin in when you saw the skull?
It was terribly decomposed.
Okay, and could you see any of it? Was there anything of evidentiary value left on the skull itself?
No, I wouldn't say so.
All right. Could you see any of the bone of the skull?
Well, I could see underlying bone. It was just this green, decomposed flesh attached to it.
Okay. And did Dr. Parker examine the skull at the scene?
Oh, sure. Yep.
All right.
So there was no way to tell whether this was a male or a female. This was a badly
There's no question.
degraded.
This is a non-responsive answer. This narrating is there was no question.
Yes, Mr. Wilson.
Thank you.
Sustained.
Thank you. I'll move on. Now, do you recall whether or not there were any businesses near where the skull was discovered?
Have I ever what?
Do you recall if there were businesses near where the skull was discovered?
Yes.
And what kind of businesses were there?
Wow. I wouldn't be able to tell you. I think there was a guy that had a yard of some kind. I don't think it was a junkyard. I'm not sure. But there was a railroad across the street from where the skull lay.
Okay. Do you recall if there was anything else do you recall if there was anything else of significant found at the scene?
Yeah, the bag, there was a black bag that the skull had likely rolled out of. There was a German Shepherd dog that had been instrumental in this, and that's understandable.
Dr. Hoptel,
can you hear me? This is Judge Krause. Sorry, it's one of the limitations of the technology that sometimes there's a delay. There's an objection, so if you'll stop speaking for a moment while I deal with the objection.
Can we approach you?
Yes.
Who just made that objection? Was that prosecution standing up to object? This witness is getting quite verbose in her answers. She wants to give a narrative when a simple answer is all this. That's all that's asked for, and she's testified twice about the large dog. It's getting crazy. Loquacious. Loquacious is such a great word. I'm sorry. I'm trying to monitor like 6 things at once, including Judge Simpson's
Go ahead, Mr.
courtroom.
Wilson.
Still waiting for Mr. Magoo.
Dr. Hopto, who would have been in charge of securing evidence at the scene, evidence of the skull and other things at the scene? Would that have been you?
Yeah, it might have been me, or it might have been a colleague of mine.
And do you recall how long you and Dr. Parker were on the scene?
No, I don't recall how long it was.
After you completed your duties on the scene, what did you do next?
Ask me that again?
After you completed your duties at the scene, what did you do next?
Okay, then I went back to the office, brought Dr. Parker back, and started to write up my report.
And was there do you know if there was a formal autopsy of the skull and whatever evidence was found?
Yes, there was a formal autopsy of the skull performed, definitely.
And where would that have been performed?
Say this again?
Where would that have been performed?
At the Fulton County Medical Examiner's office.
And do you know when that autopsy occurred?
I'm not understanding.
Do you know when that autopsy would have occurred?
Would I have known when
I'll move on.
Or did it occur? It would have been that afternoon or the following day.
Thank you. Who was the first person that law enforcement thought this might be the head of? You understand what I'm asking you?
Yeah, ask me that again because I don't know.
Did you review dental records to try to determine whether or not this was the skull of people that were coming in?
I don't understand.
Okay. What did you do first to the skull in your duties at the medical exam?
My duties, I just examined the skull's dentition.
What did you do after that?
What did I do after that, or no, during that?
I watched the video of the dog.
Did you take an x-ray?
No, I didn't take x-rays. The morgue staff did.
Are you familiar with NCIC, the term NCIC, what NCIC is?
Yes, I am.
And did you utilize that at all?
Yes. So when I did my examination, which is like a dentist doing an exam in their office, I render a chart. So I write down the features that are present in this mouth, going from the upper right, going all the way around, upper teeth, lower teeth. And on this NCIC form, I'm writing down what I found. The most significant finding was a filling on a single tooth, a single molar in the skull.
Can you hold on just a second?
Are they going to have to correct her testimony to show that she did, in fact, take a x-ray? Let's see what happens here. That which will damage her credibility a little bit. She testified that she didn't, but there's a...
It would be better if it was a complete copy.
It would be better if it's a complete copy, says defense. We don't like that. We want the whole thing.
So I'm going to show you what's been marked as States 77.
Holding it up to the computer.
That's my dental chart of the decedent.
And is that the documentation that you recorded at the medical examiner?
Yes, it is.
And was that an accurate picture of what you found after your examination?
Absolutely. You see this filling on the lower.
Hang on,
that's the
hang
lower
on,
right.
hang on.
Over,
Sorry, Dr. Hoptel, forgive me for interrupting. You've shown her the document. She's identified the document.
Yes.
But now she's testifying about what's in the document.
I know, Your Honor. I was going to ask to admit State 77.
Any objection, Mr. McDermott?
No objection.
Exhibit 77 is admitted.
Thank you.
Go ahead.
Now, what I'm doing is pointing at something on the chart. Is that what was significant for you?
yeah, that's a silver amalgam filling on the chewing surface of tooth number 31, a lower second molar.
And
there were no other fillings. There were no other missing teeth. So we delight in this because it doesn't take a whole lot of rocket science to compare dental charts to this one.
And what you would do is compare dental charts that came in and see if they match, correct?
Yeah. Yeah. And or x-rays.
Do you recall how many unknown people, do you recall how many records you were asked to identify?
Oh, no, I have no idea. There were just people galore wanting to know if this was somebody of interest to them. So I got several calls from people over time.
Did you finally receive any dental records from, excuse me just a minute. I'm showing you what's been marked as State's Exhibit number 33. I'm trying to hold it up as well as I can.
Mm-hmm. Mm-hmm. You're going to have to turn that one over. It's upside down. There you go. So show this to the jury, please.
Well, not yet. Not yet, because it's not in evidence yet.
Okay. Do you recognize those records?
Yes.
And
add that to anything goes.
What are those records?
What?
What are those records? What are those records? Do you recall what those records were?
She's like, well, how am I supposed to know? No.
I'm not sure I understand the question.
So did you recognize those records when I showed them to you?
Yes.
What are they?
They were dental records from a person named Melissa Wolfenbarger.
Okay. Your Honor, at this time, I'd move to tender States 33.
Mr. McDermott? 33 is admitted.
Thank you. Yeah, sure. Your Honor, I'd ask permission to publish number States 33.
Permission granted.
Thank you.
We're now going to be looking at some dental records. Potentially. Here we go. All right, there's the molar. You can see clearly the second
and
molar.
Dr. Hopto, what was significant about those records that you received, comparing them to the records of the remains found?
The most significant thing is that silver amalgam filling on tooth number 31. That would be the patient's lower right.
And did it match what you found from this on the skull?
Yes, it did. And the fact that it was the only restoration in the skull is to be made note of.
So after comparing the dental charts and the records of the dental charts from Dr. Brantley, and then the dental charts from the Fulton County medical examiners, were you able to determine, based on a reasonable scientific degree of certainty, whether or not those were from the same person?
Yes, I was.
Okay.
With just one filling.
And after you made that identification, what else did you do?
I'm sorry, I didn't understand the question.
After you made the identification, what did you do next?
Went to Waffle
After
House.
I made the identification, I informed the medical examiner, the medical examiner on the case.
Do you remember?
To let her know that I knew who this was, and that this was an unequivocal finding of mine.
And what medical examiner did you notify?
That would be Dr. Carol Terry. I believe she assumed the case from Dr. Parker way back in the early days.
And after you did that identification, what did you do? What did you do next in this case?
I don't know what I did next. I instructed people to notify the next of kin of this lady's death.
Okay.
I don't know what I did.
Did you ever do anything to the skull itself while in the Fulton Medical Examiner's office?
X-ray.
Did you ever do anything?
No, I did look at how the skull had been prepared by the forensic anthropologist.
Okay.
I bet she X-rayed.
Well, we don't
want that.
I don't need you to talk about that.
Please stop talking. He says you're getting us in trouble.
May I just have a moment, Your Honor?
Sure.
She doesn't remember taking the X-ray. What do you want me to do? Should I refresh her recollection? This is prosecution conferring with prosecution, trying to figure out how to proceed with their own witness, who they're now struggling with.
Do you remember what year you made the actual identification of the skull?
What year the identification was made?
Yes.
I don't know. I mean, the case was in 1998, so I don't know. It had to be after that.
Okay. Was it a long period of time after that?
He's trying not to lead.
Yes, because we only had the skull, and then there was another case that came into the office, and this was bagged remains from also somebody that had dismembered a body and put into bags. I wasn't the lead investigator on the case, but the investigator on the case, because of the similarity in the way these remains were bagged, the DNA from those remains.
Hang on, just ma'am. Dr. Hoptel?
Actually.
Hang on. Yes.
Let me ask you a different question. Let me go back to the scene of the discovery of the head. Could you describe the condition of the did you make reports on this case?
Yes.
And would it possibly help you to refresh your recollection to review your report as to when you made the discovery?
Yes.
Okay.
Can y'all come here for just a second?
Can you come here? Because she hasn't said she didn't remember anything. That's not how you do it. You can't just give her stuff saying, hey, you're not saying the right things, so we'd like you to look at your report. She's saying she remembers, and she's not remembering the same that is on your report. You can't just you have to impeach her at this point. Mr. Prosecutor, you have to impeach your witness and say, but that's not actually true, is it? Isn't it true that in 1999, when this case happened, XYZ happened? Oh my goodness, this is so good. I do think the report is the right way to do this and get her to look at that, but she brings up another murder that's got a similar MO. Oh, there's somebody else? There's somebody else out there killing people, putting their body parts in bags in a similar manner? Huh. Wonder who that could be. She just gave reasonable doubt, and they let her talk. Oh, it was so... This is crazy. Why did they not prep their witnesses? The jury must just be laughing.
Go ahead, Mr. Wilson.
Thank you, Your Honor. You wrote a report. You wrote several reports in this case, correct?
Yes.
Do you remember everything you put in the
if you
report?
wrote a report that stated that you identified the skull as belonging to Miss Melissa Wolfenbarger on the 14th day of March of 2003, would that be accurate?
Sure.
Sure. Why not?
May just have one more moment.
Sure.
Nothing further.
Mr. McDermott, questions for this witness?
Just a few.
Let's talk about the dog. Let's talk about the x-ray, which you may or may not have taken.
I would like to talk about both of them. I guess we can start with.
Defense says, oh, by the way, since you've got her report pulled up on the screen, go ahead and leave that up because I've got some questions for her.
I'll see if I can do it.
Ms. Hopdell.
Good afternoon.
Can you hear me fine?
I can, yes.
Okay.
Can you see me?
Do you remember this chart that was shown to you a while ago that you made? This was based on the skull?
Yes.
Okay. And do you have a copy of that? Or are you dependent upon my copy?
No. I have a copy.
Copy.
No. I have a copy somewhere in my file.
Okay, but not accessible?
Somewhere in my file I've got a copy.
You don't have one accessible right now?
Say that again?
Do you have one easily accessible right now that you could read from?
It doesn't matter because what I'm seeing you hold up is exactly what I know I need.
Yes.
Yes.
It doesn't
Your Honor,
matter
I'm
if
going
I
to
do
try
or not.
to publish my digital version of that. Is that okay? On Zoom?
Or is it Exhibit 77 that was admitted into evidence already?
The 77?
Yeah, it is.
Go for it.
I'm adding that one, 28. Go for it, says the judge. She's like, I'm here for the accident.
And we all know this is going to go as smoothly as possible.
Mm-hmm.
Sure.
Yeah, you're going to show us something on your computer that you don't want to show us. That's what's going to happen. It's going to have like Pandora or Spotify running in the background where you get his playlist going.
Hold on.
Oh, man. This is good. This is why we don't do cold cases, people. Unless you have...
Well, let me try it this way. Dr. Hopdell, in your written version of the chart that you made based on the skull, do you remember noting that there were class 5 caries in tooth number 6 and tooth number 11.
Yeah.
You don't remember that?
No, I do remember that, and it's written on the chart.
Oh, good. Well, that simplified matters. What is a class 5 carie?
That would be a cavity that was at the base of the gum line. That's class 5. The amalgam silver filling.
Okay, I want to stop you. I didn't ask about the amalgam yet.
Yeah, that's tooth number 31. That's a class 1 amalgam.
You can't stop her.
Okay, thank you.
There's no stopping this train.
Are class 5 caries more common in children or adults?
Adults.
Okay. Now, can you bring up the other exhibit, the chart from Dr. Brantley?
I love this witness. This is so good.
Now, I'm going to share with you the chart from Dr. Brantley briefly.
For the record, is that Exhibit 33 that was offered into evidence by the state?
Yes.
Go ahead. Thank you.
Can we go up to the other part of that? The records part?
There we go.
Okay.
Can you flip it?
And do we have a date on that document?
There we go. Keep flipping. Just went too far. Now scroll up. You keep clicking. I guess we'll just turn sideways.
Yeah.
Now scroll up.
Oh, well, number one, you can see.
There you go.
And this is a document that purports to be Melissa Patton's dental.
Yeah.
And
Okay.
what is her listed date of birth?
Date of birth? It says 9, it looks like 9/9/70.
Okay. And is there a date on which this medical record was created?
I don't know. This isn't my creation.
Well, do you see one on the document currently?
Check up. I don't see one. It's not at the part we're showing her.
No, I'm not looking at the whole page though. I'm only seeing
And can
from.
we scroll? There's another part that has some handwritten scribblings. See if we can take a chance on this.
Keep going.
It's
keep
the next
going.
page. There you go.
There we go.
Now
Oh,
you'll have to
right
rotate again, I'm afraid. Great, you're a pro.
Look, keep you
Can
around.
you see the chart part on the right that has some scribblings on it?
Yeah, but I can't discern what's written.
Can you make out the bottom row, the date?
289
Okay.
something?
Nope, I can't.
Okay, that's fine. Thank you. You said that you positively identified the skull as Melissa's based on these charts?
No, based on my examination of the remains, okay, coupled with x-rays that were taken, and those were compared, and this chart and the chart that I made were all compared to what we had in the examiner's office.
And what did you do with the x-rays when you were done with them?
I didn't do anything with them. They go with the file.
So there should be x-rays in the file? There should be x-rays in the file then?
Yeah, if protocol was served. This is a good question for the medical examiner, not myself.
Oh, thank you.
Everyone's laughing.
Are you aware that there were other agencies looking for the victim in this case?
Oh, yes.
What were some of those agencies that you were aware of?
Well, the GBI, for one, they were looking for a match to a decedent they had in Twiggs County. And then there were calls made from New York and all over the place.
No.
Yeah.
Okay, thank you. You answered my question. That's all the questions I have. Thank you.
Thank you. Mr. Wilson?
Dr. Hauptel?
Yes?
I'm sure, can you see the document that I'm holding up?
Yes, I can.
Are you familiar with that document?
So can we.
Yeah, but it looks like it's upside down.
Sorry. Did I get it right?
Yes, I can see it.
And what does that describe?
Hold it up again if you would. Okay, that tells you, shows you what the scene looked like.
Did you make that drawing?
Yes.
Your Honor, at this time, state would, and was that an accurate representation of what you saw that day? Was that an accurate representation of what you saw that day?
Yeah, yes. As best I could. I mean, there were pictures taken.
Your Honor, I would like to tender State 78.
Okay, I have something on the list y'all gave me as 32.
I don't believe it's the same.
Okay. 78. Any objection, Mr. McDermott?
No objection.
78 is admitted.
Nothing further, Your Honor.
Mr. McDermott, questions on those questions?
Nothing further, Your Honor.
Okay, thank you so much, Dr. Hauptel. You are free to log out of the Zoom. You are excused as a witness.
Thank you very much, and thank you for letting me serve you.
Thank you, ma'am. Have a good day.
I love her. This is so good.
Mr. Fawcett or Ms. Hilton, the state may call its next witness.
Super T.
Your Honor, the state calls Dr. Gilbo.
Okay.
Super T, formally, Mr. Jim McIntyre, might add. My milestone couldn't have happened on a better day. Love chatting the whole RA family. Thank you, member of the jury. 16 months. Congratulations, Super T. I knew it was. Well, now I know.
Ladies and gentlemen, do we feel like we need a break? Nope.
The jury's
Okay.
like, nope, don't stop this.
Thank you. When you reach the witness stand, if you would turn and face the deputy and raise your right hand, he'll swear you in.
You swear affirm to the testimony that you're about to give the truth, the whole truth, and nothing but the truth, so help you God. I do. Merci.
Mr. Fawcett, there are some exhibits from a prior witness up here, if you wouldn't mind grabbing those.
Judge, thank you.
Thank you, sir.
Who have we here? He's got a nice paisley tie on. Tie's a bit crooked with the buttons showing, but it's all right. It's better than that police detective.
Mark Gilbo, Guilbeau.
And if you would just scoot up to the microphone just a tiny bit. Thank you, sir. Go ahead, Mr. Fawcett.
Hey, Dr. Gilbo, can you tell the court where you currently are employed?
I work at the Clayton County Medical Examiner's Office.
All right, what do you do with them?
I'm a senior investigator.
Okay. And specifically, what is your role with the Clayton County Medical Examiner's Office?
Medical legal death investigation.
All right. Prior to that, have you been employed anywhere else?
Yes, sir.
And where is that?
Fulton County Medical Examiner's Office.
And what did you do with the Fulton County ME's office?
I was first an investigator and forensic anthropologist, and I got a promotion to senior investigator, and I still did their anthropology work.
Okay. And can you describe and go over your training and education for the jury?
Yeah, I got a bachelor's degree in anthropology from the University of Southwestern Louisiana in 1986. I soon started at the University of Tennessee, where I got my master's and my PhD, all of them in anthropology.
Okay. And after receiving your PhD in anthropology, what did you do career-wise after that?
I started a job at the Fulton County Medical Examiner's Office.
Okay. How many total years did you work with Fulton County?
Just shy of 25 years.
Okay. And did you continue to work in the field of anthropology itself?
Yeah, I've been a consultant with DeKalb County Medical Examiner's Office for 20 odd years.
Okay. What is anthropology?
Anthropology is basically the study of people, human beings, whether it be their culture, how they make a living, anything about them, in addition to their history, archaeology, and their physical biology, as in physical anthropology, which is the biological anthropology that I studied.
Okay. And specifically the biology anthropology that you studied, what specific topics do you cover in biology anthropology?
Since biological anthropology covers everything to deal with human bodies, there's a subsection of it called forensic anthropology, which basically applies the knowledge we have of human beings to a legal setting, so that we can determine what we can basically from a human skeleton.
AWOL, thanks for the gifted membership. Congratulations, Run DMC.
And throughout your time in Fulton County, as well as your time that you're currently employed in Clayton, did you participate in ongoing training?
Yes.
Was that on a yearly basis?
No, we don't really have yearly training. When I was at Fulton County, we had on and off training, dictated by the budget. But yeah, I have been to training since I graduated.
Do you yourself occasionally train other individuals in this field?
I give lectures and talks to different groups periodically.
And as it relates to the forensic anthropology itself, how does that field in particular assist you with your work at the medical examiner's office?
Whenever we find an individual that is unidentified, that is, can't be identified through traditional means, that is, we can't look at the person and determine who they are, if they are decomposing or skeletonized, burned, oftentimes a forensic anthropologist will come in to analyze the skeleton itself. And we can develop a basic profile of the individual to try to help the authorities identify the person.
Okay. And how many times would you say you've had an opportunity to examine, say, a skeleton as you've testified to this afternoon?
A lot.
When I was at Fulton, we had probably 2 or 3, sometimes 4 cases a year. So let's say 3 cases a year for 24 years. So you're talking 75 odd cases. And then I was a consultant at the GBI for 10 years in anthropology, and I looked at another 35 or 40, so 150 or so cases.
I was expecting more.
And when you conduct an examination of, say, a skeletal remains, for instance, what types of things are you able to determine?
From a skeleton, if we have a complete skeleton, we can determine the ethnicity of the individual, that is, whether white, black, Native American, the height of the individual, the sex, the race, ethnicity, race, sex, stature. We can't determine weight, but we can tell how tall you were.
Okay. And types of determinations that you just testified to, are those the same types of determinations that you made in your different examples as to how many times you've examined skeletal remains at Fulton County Medical Examiner's Office?
Right. I mean, occasionally we would have a whole skeleton, but oftentimes we would only have one individual bone that was found. The majority of our cases were non-human. A bone would be found, it would be brought in, and I could look at it and tell them human, non-human. When it was determined to be non-human, that was the end of it. There was no case.
Okay. Your Honor, at this time the state moved to tender into evidence Dr. Mark Gilbo as an expert in forensic anthropology.
No objection.
Go ahead.
Okay. Now, Dr. Gilbo, when you testified, when you were employed in the Fulton County Medical Examiner's Office, did you assist in an investigation into the death or the cause of death of Melissa Wolfenbarger?
Yes.
And what was the nature of your assistance with that case itself?
Basically looking at some of the skeletal remains that were found on apparently 2 separate occasions.
Okay. You were aware of the skull being located in April
99?
That was the first thing that was found.
All right. And you're also aware of the extremities being located in June of 99?
Yes, sir.
All right. And can you tell the court what happens to a body or a set of remains once it comes in? How is that identified from, say, any other case in the medical examiner's office?
As a case comes in, it's assigned a specific case number so that we can keep track of it. In this particular case, since remains were found at two separate times, we had one case number for the first piece of remains and then a separate case number for the second set of remains. And we're not like the medical records at the hospital where they can join them together under one number. They stay as two separate sets of remains, even though in the reports it'll say associated, these two cases are associated with each other.
Okay. And are you aware whether or not that happened in this particular case, in Melissa Wolfenbarger's case?
Right. At a certain point, they determined that all of these remains were from the same person.
Okay. Do you recall what the two different numbers associated with the skull that came in April and then the remains in June of 99? You familiar with that case number that was assigned?
I don't remember specifically, but the first case number was like in the 700 range, and then I think the second case number was in like the 900 range.
Okay.
So there were approximately 200 cases that occurred between the finding of the skull and then the other remains.
And does the medical examiner's office document their findings and investigation in reports?
Yes, sir.
If you were to review a report from the medical examiner's investigation, would that refresh your recollection as to the numbers that were assigned to the skull and the remains of Miss Melissa Wolfenbarger?
Yes, sir.
That was proper refreshing of recollection. He said he didn't remember. He asked him a question if looking at this would help. He said yes, it
I'm
would.
going to show you this front of the report. If you could look at the numbers and see if that refreshes your recollection as to those two different case numbers.
Yes, sir. That looks like them.
Okay. And what are those case numbers?
99-0798 and 99-0990.
Okay. And what happens after, say, a body or remains are accepted by the medical examiner's office?
Typically, when remains come in, they'll be stored in our cooler until the pathologist, typically in the morning, will come in and the technicians will get the remains out for the pathologist to perform their examination, whether it be an autopsy or whatever may be necessary.
Okay. And are you aware of whether or not that happened in this case?
As far as I'm aware, it did happen, yes, sir.
Okay. Talk about the distinction between, say, an anthropologist such as yourself conducting an examination of remains versus, say, a pathologist.
Okay, the pathologist is basically looking at, more often than not, a fully fleshed person. The point at which the body is too decomposed for them to do everything that they need to do, oftentimes they'll call in an anthropologist, and we will prepare the body, basically examine the skeleton at that point.
Okay.
Renee, thank you very much.
Right.
Appreciate the kind words.
At any point, did you get an opportunity to view the remains in the course of your investigation with the ME's office, the remains of Melissa Wolfenbarger?
Yes, sir.
And are you familiar with some of the efforts in place to try to make an identification?
Right. Yeah, there were quite a few sets of dental records that I remember that had come in, people that were missing, and at first all we had was the skull. So teeth were the main thing that we were able to use to try to make an ID. So there were numerous sets of dental records that came in for us to try to make an ID.
Okay. And what is that process in your role as an anthropologist? What methods would you use to try to figure out who this was?
Well, as far as the dental records, we let our forensic dentist do that part of it. But for the rest of the skull, there's certain things that we can use. There's a sinus in your frontal bone that if you take an x-ray of your skull from front to back, you can compare a X-ray before death with an X-ray of the skull, and you can basically overlay one and the other, and they'll match basically almost as good as a fingerprint.
Okay.
So, but you have to have somebody to match it up with.
Was that an issue in terms of conducting identification, not having a basis to compare it to?
Right, yeah. There's no big database out there that you can just put information in and it spits out an answer.
All right. At any point, did you attempt to make any types of reconstructions?
I did not, but at some point, I believe they did do a reconstruction, probably having it sent out to the GBI to have the skull reconstructed. As far as putting clay on the skull to make it look like an actual person's face, that's one of the things that we do at a certain point in the investigation.
All right.
Road trip. My local Waffle House is not good. It's the one we all got sick at when we ate. And it was pre-COVID. Allie G, thank you for the kind words. Congratulations on 3 months.
Mr. Fawcett,
yes.
Am I correct? You're about looking at photographs?
That's correct, Judge.
Okay, can you tell me which ones they are?
Yes. That would be 37, 57, and 61.
Jennifer Cockfield.
57 and 61.
Thank you.
37, 57, and 61.
Thank
for
you.
your generous gift. And you
So, ladies and gentlemen, I'll just
James
remind
with
you
it.
again that,
Right in the forehead.
as I warned you at the beginning of the trial, that the next series of photographs, as you might have inferred, will be somewhat graphic, given the nature of what they'll show. So I'm giving you a moment to brace yourselves.
Brace
Thank you.
yourselves, everyone. Take a deep
Now-
breath. We might see these.
Dr. Gilbo, I'm going to hand you what's been marked as States Exhibits 37, 57, and 61. Can you can open that folder? If you recognize the images depicted on those exhibits.
Yes, sir.
Okay. Now, are you able to tell from the photographs themselves where those photographs were taken?
Yeah, this was most likely in the autopsy room at the Fulton County Medical Examiner's office.
Okay. And you've been in that room yourself?
Many times.
All right. And that would have been during that period in when the remains were located? You would have been in the medical examiner's office at that time?
Yes, sir.
You testified as to numbers associated with the case, 2 numbers in particular for the cases that came in. The case for the skull, I believe you said that was 99-0798, and the case assigned to the extremities, that was 99-0990. Is that correct?
Yes, sir.
All right. On those images depicted in 37, 57, and 61, do you see anything representative of those numbers that I just read into the record?
Right, on the little tag that's in the photograph, typically that would include the name of the decedent, the date, the case number, and which doctor is assigned to the case.
Okay. Now, is that labeled as your recollection as records would have been kept in a normal course of business at the medical examiner's office during that period that you were there?
Yes, sir. That's how they would keep information in the photograph.
Okay. And your testimony is that you were present in the office at the time that Melissa Wolfenbarger's remains were being investigated?
Yes, sir.
And what work in particular did you do on this case itself, if you can recall that?
Basically, I looked at the skull. I can't remember exactly who cleaned it off, but the skull was cleaned of tissue, and then it was presented to me to do an analysis, and the skull had been autopsied. So in order to do my measurements, we do a combination of looking at the skull and measurements. Looking at it is one thing. Measurements, you hope that you have a complete skull. Well, since it had been autopsied, the top of the skull had been removed. So I had to reapproximate the top of the skull on the remainder of the cranium with some wax as best I could put it back together. So after that was done, I did do my measurements.
Okay. And what do you mean by measurements?
We have specialized tools that we have a certain set of measurements that we can do that we then plug into a discriminant function formula, and it will determine first whether the individual is male or female, and then also a slightly separate set of measurements will determine the ethnicity of the individual based on people in the United States, Caucasian, African American, or American Indian.
Okay. And can you say, based off of your recollection and your viewing of those exhibits depicted in States Exhibit 37, 57, and 61, that those are the photographs that were taken at or around the autopsy of Melissa Wolfenbarger?
Yes, sir.
And those are the photographs that were taken at the time you were employed with the medical examiner's office?
Yes, sir.
Your Honor, at this time the state moved to tender in evidence States Exhibits 37, 57, and 61.
Mr. Chairman, 37, 57, and 61 are admitted.
Kelly H., thanks for the gifted membership.
Permission granted.
Sometimes Fulton County shows stuff. We'll see what happens here. I don't think they will, but I make no guarantees.
All right, for the record, Your Honor, I'm publishing States Exhibit 37. Okay. Can you see that exhibit on the screen, Dr. Gilbo?
Yes, sir.
All right. What are we looking at?
This is a cervical vertebrae, a vertebrae in your neck.
All right. And is there anything of significance about this particular vertebrae?
The surface. Can I
If
stand
you want to
up?
get up and, yes, you can.
Okay.
Just watch your step. Don't fall.
This is the canal where the spinal cord goes. This would be the back of your neck. This would be the front of your neck. This is the body of the vertebrae, and these are the facets that allow you to move turn your head. So even though you can't spin it around, you can look from side to side with the flexibility that this allows. Now, this surface and this surface has been damaged. Something has cut through this plane of the vertebrae and separated it from the one that was next to it.
Dr. Gilbo, have you at any point studied the effects of, say, saws or mechanical instruments on bones themselves?
Yes, sir.
What do you mean by that?
I did a master's thesis on saw marks in bone.
Okay. So is it safe to say you're pretty well versed in the effects of, say, saw and the results of saws on bones?
Yes, sir.
Wow. He's got the dip the head to reinstall glasses maneuver down.
Now I'm going to show you what's been marked as States Exhibit 57.
Wonder if he can do that in reverse. Go like flip them up. We are getting to the saw marks part of the testimony, which we also heard in the previous trial. There's an objection. Sidebar ensues. So he dealt with like 150 cases in his career, but they're not just doing autopsies. There's a lot of autopsies. He's dealing with finding like skulls and, decomposed remains. So I imagine there were probably fewer of those than just regular autopsies. Glasses up, glasses down. Boom.
To be clear, I
He's showing
think
off now.
based on the sidebar that the objection was withdrawn. Is that fair, Mr. McDermott?
For now.
Okay. Go ahead, Mr. Bossett.
All right. All right, so for the record, publishing States Exhibit 57. Now, Dr. Gilbo, if you wouldn't mind shutting down from the seat, and you see the same, I'd like to get you, well,
And I'll just ask, you're perfectly fine where you are, but when you do speak, if you'll just try and speak up because you have your back to me and the court reporter. Thank you, sir.
is that the same medical examiner number referenced in the report?
Yes, sir.
All right. And what are we looking at here, if you can tell that from that photograph?
This is a long bone. I'm not sure which one it is just from this photo, but it's either the shaft of one of the bones of the arm or leg. I can't tell.
It's either an arm or a leg. Great.
And can you see anything else depicted on Exhibit 57 of significance?
Yeah, it appears that this bone was cut with a saw.
Okay. And why do you say that?
There are striations here that are consistent with a saw. There's a groove here that's consistent with a saw blade. And then it's apparently was cut through up to a certain point, and then the remainder of the bone broke.
Okay.
It was cut all the way through.
All right. If I could have you remain up there, I'm going to show you one more exhibit.
We'll just look at the judge because it's pretty much the only safe place in the courtroom to look. Judge is not really liking these pictures either.
Now showing you what's been marked as States Exhibit 61. Can you tell the court what we're looking at? Is that a, well, first, yeah.
Hey, well, thank you very much.
Is that another photograph from the autopsy of Mr. Wolfenbarger?
Yes.
Okay. And is there anything of significance that you observe or are able to observe on that States Exhibit?
Yeah, this is a cross section of the long bone. So this is a bone that has been cut completely through.
I think it's Mountain Dew.
Here. This is typically what we see when a saw cuts through an object. In this case, a piece of bone.
Now, I'm going to show you States Exhibit 66. Do you see that?
Yes, sir.
All right. Is that the type of saw that would make the types of marks on there? I'm not asking specific blade.
Right.
But is that the type of instrument that could cause the marks depicted on those exhibits?
Yes, sir.
All right.
So they just showed a picture of a saw. And he's like, yep, that could do it.
Sure.
Imagine when the judge has to bring the knuckles of justice down on somebody, that ring can really do some damage.
Now, Dr. Gilbo, we're talking about remains from April and June of 1999. Was the medical examiner's office able to observe and notate what appeared to be tool marks on those bones at that time?
Yes, sir.
So well before 2003, is that safe to say?
Yes, sir.
Okay. And at the point when you got involved in the case, it would have been back in that 99 period when the remains were located?
Yes, sir.
All right. That's all I have, Judge.
Thank you. Mr. McDermott, questions for this witness?
Yes, ma'am.
Glasses up.
You referred to the skull as having the flesh cleaned. Is that the process?
Yes, sir.
I'm sorry.
You were nodding. I just want to make the record clear.
Works for me, but only me.
He's like,
is that the process that it speaks of in the reports of soaking the head in bleach?
Right. That's one of the ways that they use to try to remove some of the flesh from the bone.
I see. And did they use other methods for other of the remains?
Sometimes we will heat up the remains in some water with detergent. We're basically trying to remove the flesh, and heat is one of the ways that we can do that.
I see.
Not pretty. Basically cooking the remains to get rid of the flesh.
You mentioned something about taking measurements of the skull.
Yes, sir.
Is that what's known as the Giles-Elliott discrimination?
That's one of the ways, yes, sir.
Okay. Did you perform that in this case?
Yes, sir.
Okay.
They're not slipping down. I'm impressed. This man has very talented eyebrows. And boom, there. I look away for a moment, and boom.
You could look at those two documents and tell me if you recognize them.
Yep, that's the.
You can say what they are.
Okay, that's the graph and the measurements that we take typically.
And the second one?
And the second one is just all my measurements.
There's a lot of measurements in there.
Yes, sir.
How many measurements do you have to take to complete this process?
There's 8 basic measurements, and then for some of the discriminant functions, you don't use all of them, but people smarter than me have figured out how to do this. I just use their method. Okay. And we basically plug the measurements into the formula, and it spits out an answer that we can graph on a chart.
But you couldn't do the work yourself.
These are the graphs you're speaking of?
That's the graphs, yes,
and
sir.
The graphs tell you whether the head is male or female?
Based on the measurements that are taken, yes,
and
sir.
Whether it's a black person or a white person?
Yes, sir.
Okay. And do you know when this method was created?
Oh, a lot of it was based on anatomical collections. They used some of the remains of service people that were killed in the Korean War back in the 40s and 50s, as I can recollect.
Okay. So this is a method that had been around since the 40s and 50s?
As far as I'm aware, yes, sir.
Okay. And based on your conclusions on those calculations, you returned a conclusion that it was a white male skull?
That's correct.
Okay. And do you remember saying at the beginning of your direct examination that one of the functions that you guys perform is that you can develop a basic profile of the individual?
That's correct.
And in this case, you thought the basic profile of the individual was a white male?
That's correct.
I don't have any other questions.
Thank you. Mr. Fawcett, any additional questions?
Yes. Dr. Gilbo, was there any information as to damage to the skull that was recovered from Mr. Wolfenbarger?
Yeah, I think there was some minor damage to the skull just from being out in the field, but then the top of the cranium was removed at the time of the autopsy prior to me being able to look at it.
Okay. And we're talking about the measurements. What are you comparing those, what is the standard that you're comparing the measurements to?
The discriminant function was developed by the Giles and Elliott crew, and basically they measured a whole bunch of skulls and then were able to look at certain measurements that were more male and some that were more female. So depending on where the measurements that you took fell in the spectrum, you would classify it either as male or female.
Okay. And what is the purpose of, say, the investigative tool? What does that serve, or what stage does that serve in the investigation process?
We're trying to develop a profile of who we might be looking for, but with human populations, not everybody is the same. So that we're trying to quantify something that removes the human judgment from the equation. Everybody should be able to take a measurement the same, whereas I can look at something and say that box is square. Well, another person would say, well, that box is a rectangle. So it removes hopefully removes the judgment part of the equation.
Okay. Well, what is the answer to explain or the explanation for Dr. Gilbo initially determined based on that scale that it was male. So how do we get to that point, and what's the explanation for that?
What we do is done by human beings. We don't know what the answer is. All we can do is take measurements, and whatever the answer comes out with, that's what we go with. In this particular case, it came out, the measurements declared that it was a male, when in fact, in hindsight, it was a female. But as with everything in a biological system, there are some that are slightly different from the others. So there's variability within human populations. So the combination of the skull being autopsied and possibly that it was into the male range, being a female, it's,
okay, just
one of those things.
And did that contribute in any way to, say, the identification itself?
Yeah, it by us thinking that it's a male, and so we're looking for males, we're not looking for females. So yeah, that was kind of a problem with the identification in the beginning.
Okay, and you're familiar with the name Dr. Joseph Parker?
Yes, sir.
Are you familiar with where he was conducting his duties as ME at that time?
Yes, sir.
And where was he conducting his duties as ME?
He worked for us at Fulton County. He also worked out at the GBI, and he was also the medical examiner for Bibb County down in Macon.
Okay. And are you aware of a headless corpse that was located, male headless corpse that was located close to Macon during that period of time?
Right. Dr. Parker generally worked on the weekends, and I believe that these remains came in on a Friday. So when he came in on Saturday, this was one of his cases. So he had just come from Macon where a body had been found with no head. Well, he shows up the next day and there's a head with no body. So the assumption from the beginning was, well, we're going to see if this head matches this body.
We're going to connect the two dots.
So early on in the investigation, there was a theory that might be the case.
Right.
All right. And did that contribute, or was that a factor in the overall investigation into determining the ID?
I think it had an influence, yes, sir.
Okay. All right. That's all I have, Judge.
Mr. McDermott, anything else?
Thank you for all those who have clicked like on the channel. It really does help out the channel. It is free.
Do you remember about what time it was in the United States that we began using DNA testing for identification purposes?
As far as I'm aware, it was maybe the late 80s when it became available.
And it was certainly available in the late 90s, correct?
Yes, sir.
And so you wanted to identify who this head belonged to, right?
Yes, sir.
So why was not the first thing that you did preserve DNA?
I looked at the bones, not the tissue. That would have been the prudent thing to do. Preserve tissue before anything else is done.
Okay. All right. No further questions, Your Honor.
Thank you. Mr. Passett, anything else?
Nothing from this witness, Judge.
Thank you, sir. You may step down. Your excuse as a witness. Can y'all come here, please?
Y'all get your butts up here. Sidebar time. I think the judge is talking about schedule right now. We are at 4:50. Did you just check the clock? Yep, it's 4:50. I think we're going to be done. Just like, look, get up here. Get up here. Don't make me yell. Is that it? Okay. Got something tomorrow? Yeah, so they're talking about scheduling. AWOL Podcast just gifted a membership. Jennifer Cockfield just gifted another membership. Went to Peter Steele. That's awesome. You guys are most generous. Rona and Peter, congratulations. And thank you for those who are clicking the like button because that was triggering the gifted memberships. So thank you. We're getting close to closing time. Yes, it's close to the time where you don't have to go home, but you can't stay here anymore. As the song goes. We have 693 of you who have clicked the like button. We like to get to 1,000, which means we'll need a lot of people to click the like button who have not yet clicked the like button. I do know that a lot of people lurk when they listen to the channel and just turn it on and leave it going in the background. So appreciate you guys doing that as well. That helps as well. Peter says, wow, I've only just started to chat. I know, but you're back, and we've got you that orange courthouse. It looks great. Jade, wow. Jade just gifted 10 memberships. Jade, thank you so much. That is super generous. Way to go. Great people cashing in, getting green right now. Thank you, Jade. That was super generous. Jade, I think you gifted some yesterday and I missed you as well. Is that true? If so, I do apologize. I try not to miss any of those generous gifts, and I know I missed some, but probably the best shot we've had of our defendant throughout the trial.
I was inquiring about, timing of what we do next. So it's getting near 5 o'clock, so I'm going to excuse you for the evening here in just a moment. I want to tell you a couple things. Number one, I have some matters that I have to take care of tomorrow morning. And I think one or two of you have some other matters that y'all need to take care of that I promised I would accommodate. And so I don't want to run into a situation where I told y'all to get here at 10:30 last time and we didn't start until much later than that. So I'm going to tell you not to arrive tomorrow until 12:30. So hopefully that will give you a good night's sleep, let you sleep in, and get here at 12:30 with no traffic. Have a chance to eat lunch, all that good stuff. We'll get started promptly at 12:30 when you arrive.
Perfect timing.
So I am going to release you in just a moment. I'll just give you the same instruction that I've given you each day, which is just to remind you that your decision in this case is supposed to be made only based on the evidence that is presented to you in this courtroom. And so that means that it would be improper for you to do any independent research, to go drive by anywhere, to look anything up or anything like that. It would also not be proper for you to discuss this case with anyone or to allow anyone to discuss it with you or in your presence, and that includes amongst yourselves until it's time for you to actually deliberate the case. The last thing I will remind you of is that there may be media about this case, and so it is your sworn duty to avoid media about this case because, again, your obligation in this case is to decide the case based on the evidence presented in the courtroom. With that, I thank you again for your patience and attention today. I'll excuse you and see you tomorrow at 12:30.
All right, we're going to bail on them. Late start tomorrow. We're going to jump over to Judge Simpson's court where Mr. Magoo just arrived. It's great to have you here, Mr. Magoo. Literally just moments ago walked into court. So I'm going to leave these guys right there. Let's stop that one. Oh. Continue. What did I just do? Okay, dang it. Okay, I used the wrong button. Okay, I'm going to go back over here. And hang on. Let's get to Judge Simpson on this one. Judge Cedric Simpson. Pull it up. There we go. We have to go back just a teensy bit. I want to hear anything the judge said before he came out. There we go. All right, here we go. All right.
Charges, and we waive the formal reading.
Defendant may waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for September.
I'm going to change the speed on this to be 1.25 so we can catch up in case we miss anything. Okay, now play.
8th, September 8th, 2025, 1:30. That is before Judge Hood.
Thank you, Your Honor.
Bond will continue.
Don't have one agree.
Mr. Warren, I was going to do Magoo to get the jail out, but
He's coming out. I'm going to hear you. Yeah, he's right. He was just in here, Your Honor.
We're going to do Magoo.
Well, we'll do at least one of Magoo. Are you sure it's only 3?
What?
There we go.
There's the file.
Yes.
Court does, well, I get his attorney in. Court does call the case This is Other People versus Daniel Magoo.
Ashley Feltus for the people.
Good afternoon, Your Honor. Alex Warren Green on behalf of Mr. Magoo.
Mr. Magoo has representation, but he will speak.
Mr. Magoo, can you speak? Daniel Magoo.
Thank you.
Your Honor, the defense is ready to proceed to examination in each matter. I'd ask for a sequestration order.
I anticipate one witness in each case.
All right.
So we should be open.
All right. Witnesses are ordered sequestered for what that matter.
Actually, Your Honor, I have
you may have, yes.
I have an issue. I have been requesting the last time I was here, requested that the prosecution provide explanation for the undue delay.
Your Honor, my advice to Mr. Magoo was that I'd be handling the examination today. So just for purposes of the record, I'm advising you not to make any statements on the record.
Well, I do actually also want to provide notice that this case is being removed under 28 U.S.C. 1455 to the Eastern District of Michigan under case number 25-12440, and due to due process violations that I've been facing.
I don't know what you're talking about. The case has been removed.
Oh, I'm sorry. I'm providing notice of removal under case number 25-12-12440.
Have you talked it over with your attorney?
I let him know.
Your Honor, and my advice was I'm not going to be joining in any collateral motions or actions, and that I would address the case.
Are you aware of any motion that seeks to take this case to federal court? I'm not sure how that would even happen.
Right, Your Honor. And Mr. Magoo told me that he has been seeking that action, but I informed him that I am not a member of the federal bar and I would not be joining him in any of those actions.
Just providing notice.
Just
okay, I don't know what the notice does, but I'm not. If I don't have something in writing indicating some procedural aspect to it or anything along those lines, the court's not.
I would advise against.
I don't even know what is
notice of removal pursuant to 28 U.S.C. 1455 criminal.
What does that statute read?
The criminal proceedings removed to federal court under federal questions involved in this case.
I'm not going to bite as to what federal questions, because I don't think there are any federal questions.
What's the number violation?
Which adequately a state court could handle if that were an issue. So I don't think there's any need for the court to even deal with that. I don't know that anything's been filed with the federal court regarding that or anything else.
Filed under case number 25-12440.
I keep saying that number.
Are we ready to proceed?
The defense is ready to proceed, Your Honor.
You ready to proceed?
Yes, Your Honor.
All right. Which case would you?
We were talking over each other. I apologize. If it pleases the court, could we start with the OWI matter?
OWI comes first.
That being 0523.
I believe that's correct.
Here, just shut up and color. Gives him a little
That's
notebook.
Right. Start with that one.
Thank you. A couple of housekeeping matters. The court is in receipt of the amended complaint, which is just taking credit of felony form. Is that correct?
I do have an amended information. I do.
Excellent. And Your Honor, I do believe defense is stipulating that the defendant has 3 prior OWI convictions.
So stipulated, Your Honor.
3 prior DUIs.
So there's a stip to the priors.
There is, Your Honor.
All right. Anything else?
I do think defense is going to stipulate to People's Exhibits 1 through 10, which are photos, but maybe not.
Your Honor, I did have an opportunity to review those, and we would so stipulate.
And then People's Exhibit 11 is a laboratory report. I'm not sure if there'll be a stipulation to that as well.
We would so stipulate.
I'm sorry?
So stipulated, Your Honor.
Okay, so exhibits 1 through 11 are stipulated to.
Thank you, Your Honor.
Therefore admitted.
Thank you. I do expect that the officer in charge of the other matter will probably be informed at some point if sequestration orders otherwise enacted and followed. So I call Paul Corey to the stand.
All right. Please come forward to be sworn.
Well, they call this witness. If I slow this down, we will miss the end. I can't slow it down. It will, in about a minute or two, it's going to just go to normal speed anyway. Just hang in there. If I slow it down, we'll miss the end.
All right. You may inquire.
Good afternoon, sir. How are you employed?
I'm employed with the Milan Police Department.
How long have you been employed with the Milan Police Department?
A little under 2 years full time.
Do you have prior law enforcement experience?
Yes, I worked at the Washington Sheriff's Office prior to that for about 15 years.
Were you working for the Milan City Police Department on or about March the 27th, 2024?
I was.
Do you recall what shift you were working that day?
In my shift, 6 p.m. to 6 a.m.
And were you ever at the location of Dexter Street and Arcona Road?
I was.
About what time were you at that location?
About 1:35, or when I was dispatched there.
Why were you dispatched there?
The 911 caller said that there was a single car crash into near a gas station in that area.
Did the 911 caller, did you have any other information in your dispatch when you were headed that way? It's not being offered to prove the truth of the matter asserted. It's being offered to prove why he was headed to that location and other additional information that may have hastened his speed going that way.
All right. I will overrule the objection regarding hearsay. I'll accept it for what it's offered for, other than the truth of the matter.
Thank you. Did you have any other information from the dispatch?
The caller said that there was a single subject walking around outside of the car and potentially, possibly injured.
And did you make that location?
I did.
Do you recall about how long it took you to get there?
Maybe about 5 minutes, less than.
Less than 5 minutes. When you arrived, what did you observe?
A car that was, I saw the SUV that was appeared to have been crashed into a sign outside the gas station here, Dexter, and there was a single male subject standing around the passenger side of the vehicle.
What did you notice about the vehicle first?
It was definitely crashed there and not parked. This makes sense in front of it.
And Your Honor, may I approach with People's Exhibits 1 through 10 for the court?
You may.
Thank you.
Hey, you can slow it down on your end if you need it slowed down.
Officer Corey, you took some photographs that evening.
Yes.
Did you take a photograph of the vehicle as you found it?
I did.
Actually, more than one, would that be fair to say? And when you saw the vehicle, how did you determine that it had been crashed as opposed to just parked there?
Due to the amount of front end damage that it had, it was still in contact with the signage there.
Did you make any observations about any other parts of the vehicle?
It was the windshield was smashed in a particular fashion.
And go ahead.
It appeared that it was impacted from the inside rather than the outside.
How could you tell that it was impacted from the inside rather than the outside?
It was falling outward instead of inward, and there was no like gouging from the outside of the windshield.
And when you were looking at the windshield, would you describe the cracking in any particular way?
In a circular fashion. It's probably the driver's seat.
A circular fashion.
Did you look inside of the vehicle?
Yes.
Where did you observe about the inside of the vehicle?
There was quite a bit of personal property inside of the vehicle, and the passenger and all the front and rear passenger seats, indicating that there was probably only one occupant at the time of the crash.
Did you look at the windshield?
Yes.
What did you observe about the windshield?
What stood out about the windshield was there was a lump of human hair attached to the cracks in the impact area on the inside of the windshield.
There was a clump
How
of
would you
human
characterize
hair.
the color of the hair that you saw?
Light brown.
It was Magoo colored.
Maybe dark blonde.
Did you make contact with any people at that location?
Yes, there was a male subject standing near the passenger side of the vehicle when I arrived.
Do you see that person in the courtroom today? Can you tell me where that person is sitting and what they are wearing?
Seated unstable under the green jumpsuit.
Your Honor, may the record reflect that witnesses identify the defendant?
No objection, Your Honor.
Record shall so reflect.
And sir, when you made contact with the defendant, what did you talk with him about, or what did he do?
I asked him what had happened.
What did he say?
He said I wasn't here.
What else did you notice about his appearance?
He was bleeding from a cut or some type of injury. There was a lot of blood. It was not know where it all was coming from. It appeared it was bleeding from the top of the head.
Did you notice anything about his clothing?
It was disheveled. And there was blood on it. Front zipper was down. The zipper was down on his pants.
He was just hanging out next to the accident.
Did you look at the color of his hair?
Yes.
Based on your observations, did that appear consistent with the color of the hair in the glass inside the car? What happened next?
He maintained that he was not driving the vehicle. He could smell the odor of intoxicants coming from him. We called for medical assistance just based on his injuries. And so while they were on the way, asked if he would take a preliminary breath test, which he agreed to.
Without getting into the results of the preliminary breath test, did you make a determination about what had happened that evening?
It appeared on his face that he was driving the vehicle and it got into a crash. And he may have been intoxicated while he was doing it.
Did you place him under arrest for OWI?
Not at that time.
When did you place him under arrest for OWI?
After the ambulance came, it was determined he was going to go to the hospital while he was receiving medical treatment, and I read him his chemical test rights. I advised him at that point that he was under arrest.
Did he agree to take a test?
No.
What happened?
He refused to take a test. Poor judgment on my part. I did not have him restrained in the hospital bed. Well, I left I believe that his injuries were significant enough that he was not going anywhere. I went out to my car to start preparing a search warrant for his blood, at which point a nurse came out and told me that he had fled the hospital.
Did you find him?
With some assistance from Washington County Sheriff's Office, yes, I did.
Where did you find him?
An apartment complex just south of the hospital.
Were you able to take him back to the hospital?
Yes.
And did you complete your search warrant?
Yes.
Was it executed?
I just a note for the court, Sergeant Crusadis, helped me prepare the search warrant while I was dealing with Mr. Magoo's hospital. However, I did review, since I was going to the warrant, I did review it to make sure it was accurate based on my observations at the time of the incident.
Did he make I'm sorry, go ahead. No, so sorry to interrupt you, sir. While you were waiting to do the blood draw, did he make any statements to you?
He looked at my uniform and appeared to be confused as to why he questioned me as to why Milan, the city of Milan, was doing all of this. And
what did you say to him?
I asked him where he thought he was, and I said he was insane. He thought he was insane.
Did you ask him to perform standardized field sobriety tests?
I did not.
Why not?
Mainly due to his injuries, and even though he did comply with the request for a TBT, he was generally uncooperative with most things that we were trying to get him to do, or asking questions about what had happened. So then based on the extent of his injuries, we were more concerned about getting medical attention at that point.
In your training and experience with administering standardized field sobriety tests with people who've been in traffic crashes that have injuries, is there any guidance that you've received from NHTSA on that?
It can be, especially with what was clearly a head injury that was sustained in a vehicle crash, it could have impacted the results of the standardized field sobriety test.
Your Honor, may I approach with People's Exhibit 11, the laboratory report?
You may.
And Officer Corey, you did receive a laboratory report back in this case. And do you recall what the VAC was?
I believe it was 0.127.
0.127. So it's over the limit, but it's not super drunk.
What did you do with the vehicle? Or what was done with the vehicle? Let me ask that. Do you know what happened with the license plate?
We confiscated the plate as the operator at the time, who we believe to be Mr. Magoo, had several prior convictions for suspension and operating while intoxicated, requiring a plate confiscation.
Pursuant to state law, you had to take it. And I may have a moment.
May.
They confiscated the plate.
I do have one question. How much time elapsed between the time you were notified that he had left the hospital and when he was located? Do you know?
I believe it was about 40 minutes, Your Honor.
40 minutes?
40 minutes.
Okay.
Did he do any drinking during that time?
Officer Corey, Milan, what county is that located?
Well, that's interesting. Half in Monroe County and half in Washington County. The incident itself occurred in Washington.
Thank you. And that is in the state of Michigan?
Correct.
Milan kind of abuts the two counties, correct?
Yes.
Thank you.
Right on the county line. Okay, defense.
And verify the past witness.
All right, cross-examination.
Thank you, Your Honor. May I inquire? Afternoon, officer. My name is Alex Warren Green. I represent Mr. Magoo in this case. So you're dispatched for a single vehicle accident, right?
Right.
And that's at a mobile gas station. And it appears there was an accident from an SUV into the sign, the mobile sign, right?
Right.
And
which was station.
Like you testified on direct examination, there was a 911 call placed, and that person didn't provide a name, did they?
They may have. It's something that I didn't end up following up on.
So you never talked to the caller, did you? And are you aware if anyone talked to that caller?
I'm not aware of anyone.
So as soon as you get there, Mr. Magoo is on the passenger side of the vehicle, right?
Same side. It's on the passenger side.
Okay. And that car was not registered to Mr. Magoo, was it?
Correct. It was not.
And like you testified on direct examination, he had a wound to his head, right?
Yes.
Bleeding pretty bad?
Yes.
There was an injury to the front and back of his head, right?
There's photographs of an injury to the back of his head, yes.
Okay.
And the front.
And he appeared to be dazed?
Yes, it was difficult to say if he was out of it due to the head injury or his level of intoxication, maybe a bit both.
And you didn't conduct the field sobriety test because you were concerned that the head injury you observed might impact the field sobriety test, right?
There was possibility, yes.
So you testified on direct examination, you saw the windshield was smashed and you saw blood, right?
Correct.
There's a chunk of hair in the windshield, right?
Yes.
You take a picture of that?
Yes. Let me backtrack. Sergeant Mercedes actually took a photograph of it.
Okay. And most of the time you're talking to Mr. Magoo, he was wearing a hat. You recall that, right?
I don't recall that. You may have been.
Kayla, thank you very much. This was a
So-
pro se guy. Yep. He has
It's
a
dark
lawyer
outside,
now.
right? And
Is that a yes? I don't think we got
Oh,
it.
sorry.
I'm sorry, Your Honor.
It's okay.
Yes, it was.
Okay, go ahead.
and there's a significant amount of blood on his face and it's going into his hair, right?
Correct.
Okay. In this case, you did submit evidence to the crime lab for forensic analysis, right?
Blood test, yes, blood sample.
Right. So no hair follicles, right?
No.
And there was no attempt to obtain any forensic match between the hair or the blood that was found in the car with any hair or blood from Mr. Magoo's body, was there?
You were correct, there was not.
Okay.
Defense doing a good job here.
On direct examination, you talked about field sobriety tests. You said you're trained in the administration of field sobriety tests, right?
Yes.
And you forewent the field sobriety tests in this case, but
now we're at normal
no one
speed.
asked him at all to perform those field sobriety tests, did they?
That's correct.
And after this initial interaction, when the ambulance arrives, he goes to Trinity Ann Arbor Hospital, right?
Correct.
Rona,
And
welcome.
did you accompany him in the ambulance or you follow behind?
Follow behind.
Okay. And you read him his chemical rights at the hospital while he's in the bed, correct?
Correct.
And he refused at 2:51 a.m. Is that
correct?
And after he refuses, you leave the room to go and work on the affidavit for the search warrant, right?
Correct.
And then Mr. Magoo vanishes.
That is also.
Okay. You didn't see him leave.
I did not.
You had no idea where he was.
Nope.
And like you said, he wasn't handcuffed or in any way restrained to that bed, was he?
He was not.
And there were no officers standing at the door or otherwise supervising that room, were there?
No.
And through your investigation, you determined he's located at an apartment complex at around 3:40 a.m. Is that right?
That's what is in the report. I think I listed a time in there. If you want me to look at refresh my memory.
It would refresh your recollection to look at your report?
It would.
Okay. Your Honor, if I may approach the witness.
I think it's.
He's got a copy that was turned over, so if you look at that, if you believe that will refresh your recollection.
Yes, it did. He was located about 3:40 a.m.
Okay. And he's returned to the hospital. The blood draw was completed at 4:28 a.m. And of course, there's two blood draws done. So it's 4:28 a.m. and 4:29 a.m. Does that sound right, officer?
That sounds correct.
Okay. So in an ideal OWI investigation, you want to have eyes on the subject from the time you make the scene until the needle enters the arm, right?
I do. Yes.
Okay. One of the reasons you do that is to make sure the subject doesn't consume anything that could impact the blood test, right?
That is correct.
And Mr. Magoo was unaccounted for nearly an hour in this case, right?
That's correct.
And in your search warrant affidavit, you didn't mention that, did you?
I don't believe so, no.
Thank you for answering my questions, Your Honor. I have nothing further at this time.
Defense poking
Read
holes.
Thank you, Your Honor. Officer Corey, were you able to obtain information that the defendant had previously been pulled over by a different police agency operating this car in March of 2023? And after he was recovered and brought back to the hospital, did you have two deputies stand by with him and handcuff him to the gurney?
I handcuffed him myself, but luckily I had a couple of deputies that were free for the moment that were able to watch him while I finished up the search warrant.
Thank you. Nothing further, Your Honor.
Anything?
Your Honor, if I may
May want to mute your microphone.
No, please don't. We'd like to hear this conversation. Okay.
Your Honor, just briefly. Thank you. Officer.
Oh, and can I just ask one other question before you, and I'll let you ask your question.
Of course, Your Honor.
The PBT, if there's...
Alex, muted.
Okay. The PBT, are people going to seek admission of that if defense is challenging the results
Yes, Your Honor.
pursuant to the statute?
Correct.
And Your Honor, I understand that the people could rebut that kind of challenge. I'm not sure that we have gotten to that point yet. The case law.
Well, I just want to make sure that if there is going to be a challenge to the results, that under the statute, my understanding is, although these aren't entirely the circumstance under which it happens, but it seems to me an analysis could be made that the PBT would then become admissible. Just so that defense counsel is aware, but you may inquire.
Thank you, Your Honor. I appreciate it. Officer, before Mr. Magoo was admitted to the hospital, did you yourself search him? Search his person?
It's outside the scope of my redirect, Your Honor.
I'll allow him to ask. Go ahead.
He was wearing a jacket, right?
I believe so, yes.
Did you go through all the pockets of that jacket?
I normally would, yes. I believe I did.
Okay.
I believe I did. Normally would. During this pause, I will let you know that tomorrow we'll be deleting all the points.
Officer, when you completed the refusal to submit to chemical test form, in this case, do you recall writing the refusal time as 1:35 military time?
No, I don't recall that.
Would it refresh your recollection to look at the refusal to submit to chemical test form you completed?
It would. I think.
Yes.
He's got a copy of everything. Defense lawyer is doing a much better job fighting this than Mr. Magoo would have. This is a DUI. It's a fourth DUI. If he's got 3 priors, they call them OWIs up there, but it's basically the same thing. Points are pointless. We're going to delete.
I don't recall why I would put that time there.
Well, again, officer, thank you for answering my questions. Your Honor, I have nothing further at this time.
All right. Ms. Lundy.
Officer Corey, you would agree with me that this says refusal date, but it does not say refusal time, correct? It just says military time?
Correct.
Okay, thank you. And lastly, Your Honor, in anticipation of an argument that the blood result is not accurate, I would ask a question about the PBT, but if that argument's not going to be made, then I don't need to.
Your Honor, I would object to any mention or admission of the results of a preliminary breath test in this matter. I'm not sure that I have raised an argument that regarding its accuracy or regarding a rising blood alcohol level or anything like that. I don't think I've opened the door to that.
Well, I don't think you have. I just want to make sure we're prepared for the argument. But if that argument is going to be made, then I'm going to let the people question as to that. But
Your Honor, I don't anticipate making an argument regarding a rising blood alcohol level or anything to that effect at this point.
Magoo's like, really? I thought we were going with, I might have joined later.
But are you going to make the argument that the blood alcohol result at the time of the test Well, I'll just do it this way. Is it lower or higher than the?
Your Honor, I intend to make arguments on what has already been stated on the record, and I'm not to.
What does that mean?
From the defense, I don't anticipate any further questioning regarding the blood alcohol results from either the lab or the preliminary blood test.
Okay, again, that was very cagey the way that was put, but I'll just put it this way. What I will do, Ms. Lundy, is I will not permit the questioning at this point. However, if it is raised in argument, I may entertain a motion by the people to reopen their proofs to take testimony regarding that.
Thank you, Your Honor.
Understood, Your Honor. Thank you.
I'm ready, Your Honor.
Defense is frustrated.
You may sit down, sir. Thank you. Yeah, shut down. I'm not done. So the system went down?
Yeah, it says that my calls are still recording, but
We don't know.
software shut down.
I'm not gonna take a chance. Do we know when it happened? Just now?
Just now.
Just now, okay. What the court's gonna do is court's gonna stand in recess. We need to take it back up.
Understood. Thank you.
It's worked too hard today. Court's in recess.
All right. Okay, what just happened is the court recording system just shut down. Judge says, I'm not done. Why did it shut down? So we're taking a quick break while we wait for the recording system to be booted up. He says, I'm not going to take a chance. I'm not going to go forward, especially on a case like this, with, why do I have, oh, that's the judge's mouse, not my mouse. Okay. I'm not going to take a chance on a case like this and wait. Let's see if they come back. This is live. This is happening live. Defense attorneys are talking together, as they do. It should just be a couple minutes while they reboot the system. As soon as the judge gets the go-ahead that the recording is working, then he'll come back out. But Mr. Magoo has a lawyer here for the first time. This is specifically, this is for one of the OUIs, his fourth. He's been convicted, I believe, 3 times previously. And I have to tell you that the mods hate this, but today is the last day we're going to have the slots functioning. And it's before you use it, before you do anything. We're waiting for court to come back in. This is pretty cool. Before you use the slots, just wait. You have a 1-minute timer. You can use them every minute. If it gets really crazy, I'm just going to turn them off. So bet big. Points will be deleted tomorrow. All points. So go for it. Go for it. Once we restart points tomorrow, the slots will not be active, neither will roulette. I don't think we'll even have dual functioning. So there you go. What are points for? Nothing. They're just, I wanted to do something with points. I turned it on because it's a way for people who are not in a position to financially support the channel to sort of track their progress, because if they're not a member on the channel, you can't see the colored courthouse and things like that. I brought it on for that, but the slots just, it gets in the way. It's too much. It's too Twitch is what it is. So just suffer through one last afternoon with some slots, some gambling, some degenerates losing all their points, and then it will be gone tomorrow. We will have the point system back, but it will be more based on just attendance and first in chat and milestones and things like that. So it's all right. I see some of you winning and some of you losing. It's crazy how many points you guys have accrued, but cameras are still on, so we're just waiting for the judge to come back once the recording system restarts. Shouldn't take more than just a couple minutes. If you do want to use slots, you have to first see how many points you have first. And then, who's that guy in the blue uniform? Back there. He's not a bailiff. He's got to be police. He's there for one of Mr. Magoo's. He's there for one of the trials. He's there for round 2, I think. Because we've got 2 traffic things. I wonder if Mr. Magoo is going to be represented for both of the hearings, or if it's just this OUI that he'll have a lawyer for. Mr. Magoo, against lawyers' advice and against the lawyer's wishes, interrupts the proceedings this morning to inform the judge that he is, in fact, taking his case to a higher court. He says, "I've moved this case to a federal court." And the judge said, "What does that mean?" And he said, "I'm giving you notice that I'm taking this case to a federal court because you're violating my whatever rights." I forgot what amendment he listed. Fourth Amendment rights. And the judge asked for more explanation, and Mr. Magoo kept citing a case history that the judge was not A, impressed with, or B, plussed by, and the lawyer interrupted and said, "Just so you know, I'm not joining him on any of these little extracurricular motions he's making. I'm not with him at that point. I'm only here for this one thing, and that's the one thing I'm doing, and that's it. And I do my job well. But other than that, hey, Mrs. R.A., what you making? You see you're wearing your apron. What? Do you want fried rice? Oh, man. Magoo's in Simpson's Court right now. You want to bring me fried rice? You don't? No, I'm starving, guys. My wife refuses to feed me in my office. Anyway, fun little times. The lawyer, it looks like he has a pretty good rapport with Mr. Magoo. He's probably set some very clear boundaries. And stop this madness in chat. It's almost done. It's almost done. She says we've got fried rice ready for dinner. So. Sovset complaining about constitutional rights, document they question the validity of. Yeah, they don't fall under that one. Court's gone silent here. Camera's off. Okay, about one more minute here, and we're turning off the slots. So Debbie says, I'm trying to lose my points, and it's working. You have to bet them all. You have to bet them all. Bet big. Slots are going to go off here for the last time. So water chestnuts in that fried rice. It wouldn't have it any other way. I think there's also mushrooms and bacon. Did he put bacon in the fried?
This is the hope that he won't starve at college, so he made this.
My wife gave me a plate of fried rice and then told me that my son, who was about to go to college, made this as a, yes, I can live on my own. Look, I can make food. You guys want to bless it a couple times? It smells like fried rice should. It does have bacon in it, which I've never seen before, but that's good. Not sure if that was like a whole bay leaf or what. It's different. It's different. Blink twice if you were in trouble. I'm always in trouble. It's good. It's not bad. I think it needs a little bit of soy sauce, or possibly, I'm thinking Sticker Mule hot sauce. I like that with fried rice. I think that's what it's going to use. Let me see if I can get one of my kids to bring it in for me. While we're waiting, I was going to give you an update on the Donna Adelson progress as they're looking for a seat in the jury. They haven't done it yet. They're still working on it. But I don't know the count. I know there's some people who have not been excused who I would think in other courtrooms might have been. But, yeah, it's interesting. The, let's see, Tennessee Democrat, is that who it was? I forget what it was. Tallahassee Democrat had a good story about the jury selection, just a synopsis of, if you look on Twitter, they had a synopsis report of who had what concerns, who a lot of people have heard about the case before. Some people had, one guy had watched the whole case with Charlie online because that was streamed and had some strong opinions about guilt and innocence. And so it's just the usual stuff you'd expect. All right, here we go. We're going to close down slots because it's going nuts and people can't chat anymore. Wait for it. For the last time, here we go. Commands, slots, looking for them. There they go. And they are off. All right, slots are done. Whew. There you go. I tried to lose all my points, but slots broke, says Debbie. Yeah. I see a lot of you with a lot smaller numbers. You did lose some points, so good job. And some of you won. Virginia, congratulations. You got some good points there. I'm going to reset all the balances for tomorrow. So, still waiting for Judge Simpson to come back and finish up the Mr. Magoo hearing, possibly one of two today. Best time to quit when I'm ahead. Yep. How do you get points? You get points by being here, by participating in chat, by being first in chat. Super chats and super stickers also do go towards points. I think gifted memberships do as well. There's a lot of things that add up to them. But we're going to reset all the points tomorrow, and everyone's going to be at 0. As a matter of fact, we might as well do it today because we're done with the gambling. That's going to be in our past. Let's see. Commands, points. Can't even see where the points are anymore. User levels. Nope. There it is. Loyalty points. I show by my count that Kim R was the leader with a maximum of 122,923 points. Lara Fry was in second place. Libby with 91,000. Lara, you had over 100,000. Kim at one time was as high as 145,000, which was the high. Then it followed by Greeners, Warrior Queen, Virginia Little, Stephanie, Pego My Heart, Alex Duncan, Whiskbrand, Bree, The Other Jewels, Kelly H., Melissa Webb, Camilla Juliana, Debbie M., Sherry Smith, Regina Crawford, Katrina Bunny, Just a Girl Baking, Ricky C., I Love Dogs, Martha Ivy, Barb Russell, Selena K., Donna Turner, Birdie B., Teresa K., Samantha M.B., oh, I think we're back, Anna, Red Pen, Miss McGuire, Josh Hutchins, Rana, Purple Coconut, Super Tea, in that order. DSN, Amber, Clipson's Vixen. Bite Me, you were next. All right, so we're going to go ahead and reset all loyalty users. Resetting is irreversible.
District Court for County Washington, and Michigan is now back in session. The Honorable Judge Jason. You may be seated.
All right, we're back.
Call him out, yeah.
Bring out Magoo. Gambling is done. We're all
of angering anybody. I don't think I've seen public defenders work this late. Anyway, court recalls the case, People versus Magoo.
As spells to people.
Alex Warren Green on behalf of Mr. Magoo. Mr. Magoo, could you state your name again, please?
Daniel Magoo.
All right.
Your Honor, I think we had finished with our officer, Officer Corey. I don't have any additional witnesses.
All right. Go ahead. You can have your conversation. You might want to mute the mic.
Got a little mule sauce. Oh, they're getting awfully close. Like get a room close. That was. I've seen negotiations, and that's different. They're sharing.
Your Honor, no witnesses from the defense.
All right. I have a motion.
Your Honor, I move for bind over as to count one and let counts, I think it's 2 and 3 on this web follow. I do believe we presented sufficient evidence to establish by probable cause a circumstantial case that the defendant was the operator of a motor vehicle on the date and time in question at the location in question, that he did have an alcohol content of 0.08 grams or more. Your Honor, the people were able to present evidence that there was a vehicle crash, that the windshield of that vehicle had been hit from the inside. There was blood and there was hair consistent with the defendant's hair. The defendant had a head wound on the front of his head, and that, along with being at the scene of the crash, I do believe is sufficient circumstantial evidence to establish by probable cause that this matter should proceed to trial. I'll reserve any further arguments for rebuttal.
Your Honor, the defense would object to bind over in this matter. In making the bind over decision, we'd ask the court to consider the lack of direct evidence linking Mr. Magoo to operating that vehicle. Your Honor, I have nothing further at this time. For the record, we are objecting to bind over.
I think there is certainly, when one looks at the exhibits, particularly exhibits 1, 2, 3, are the vehicle in which the defendant is around, which has crashed into a pole, and that the pole, quite frankly, did not give way much. And then what also would establish then the second piece of establishing the defendant was operating that vehicle, or People's Exhibits 4, specifically 4, which is clear indication of spider webbing, and what Officer Corey testified to are the damage to the windshield, the circular damage above the driver's side, to the window, as indicated, a circular pattern, not or similar to certainly what this court has seen over the years of individuals who are unrestrained in vehicles who are then involved in a crash, alcohol related or not, where their head strikes the windshield. And then exhibits 7, 8, 9, and then also 10 that show blood and also injuries to the cranial area or the head area of the defendant, along also with Officer Corey's testimony regarding the hair, although not analyzed, but certainly the color, texture, hair, his observations regarding the hair that is in the windshield, all certainly point to and would give rise to probable cause that the defendant was operating that motor vehicle at the time of that crash. Additionally, then there is testimony regarding blood test results, which then occurred at the hospital later that day, indicating a blood alcohol content of 0.127, which, absent anything else, could be used to presume that that was his blood alcohol content at the time of the operation of the motor vehicle. So that the record is clear, even to the extent the defendant's unlawful escape from custody at the time from the hospital may go to the weight to be given to that blood alcohol result, but does not negate that blood alcohol result. The court is sufficiently satisfied that people have sustained their burden of showing by probable cause that the defendant did operate a motor vehicle under the influence of alcohol or intoxicants. So therefore, for those reasons, the court would bind the defendant over on count 1 with the stipulations to the previous convictions of the defendant, with counts 2 and 3 following.
Your Honor, do you want to proceed on the arraignment?
Yes, let's just do that now.
We would waive formal reading of the information, stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea as to all 3 counts. Pretrial in this case will be
October 9th at 1:30 with Judge Slay.
October 9th, 2025, 1:30 before Judge Slay. That case bond will continue.
Welcome.
Can I find information, Your Honor?
Yes, you may.
Welcome to all those who came over from Broken Baker and Broken Baker yourself. Welcome. Good to have you here.
Have her exhibits back.
Appreciate those who click the like button as well. That helps the channel out.
Oh, you had an extra that you.
I had extra information.
That's fine. Court also now calls the case of People versus Daniel Magoo. That's case 25F30979.
Round 2. Here we go.
People.
Alex Warren Green on behalf of Mr. Magoo. Mr. Magoo, could you please state your name for the court?
Daniel Magoo.
All right. Ready to proceed on this case?
We are, Your Honor. Prior to beginning, I will inform the court, and I did inform defense counsel, I do intend to, if the proofs bear it out, to add account of receiving or obstructing an officer. And I believe defense counsel is aware of that. That would be contrary to 75081D as in dog 1.
Okay.
Right.
And Your Honor, to also provide notice of this, notice of removal pursuant to 28 U.S.C. 1455. This case has also been removed to the United States District Court of Eastern District of Michigan under case number 25-12441 for Fourth Amendment violations along with others.
This court has no knowledge, as I last case, of any removal, has not been notified of removal, and so has not been presented anything with removal, nor anything presented which would show a procedure in which this state action would be removed to federal court. So for those reasons, while you want to say it all the time on the record,
that's it.
To the extent it's a motion of any type, that's denied. You may call your first witness.
Thank you, Your Honor. People call Colin Cheney.
Sir, please come forward and be sworn.
Blue-eyed hillbilly. That's awesome. Catnut Williams, Broken Baker, and you're here.
Right.
Welcome.
You solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth shall be God. State to your first and last name for the record, please.
Colin Cheney, COLLINCHENEY.
All right, you may inquire.
Thank you, Your Honor.
That tie tack is a
Sir, how are you
Body
employed?
cam. Body cam.
Michigan State Police is a trooper.
How long have you been employed as a trooper with Michigan State Police?
About 2.5 years.
Do you have any prior law enforcement experience before you were a trooper?
I do not.
Were you still employed on or about July the 3rd, 2025? What were you working that day?
That was road patrol.
And where were you road patrol at? Do you recall what part of Washtenaw County you were doing road patrol at about 7:45 in the morning? Were you traveling westbound on 994?
Yes.
And is that location in Washtenaw County, state of Michigan?
Correct.
Did you notice any vehicles while you were traveling westbound on I-94?
Yes.
What did you see?
Here, westbound on 994, I observed a red sedan that looked like it was traveling faster than the rest of the traffic on the freeway.
What did you do?
I caught up to it, and when I got closer to it, my radar picked up the speed reading.
And what was it reading?
So 90 miles per hour.
What did you do next?
I got behind the vehicle, activated my overhead lights to conduct a traffic stop on the vehicle.
What happened after you activated your overhead lights?
Shortly after, the vehicle merged over to the shoulder, got down to around 40 miles an hour, and rolled for half mile to a mile before coming to a complete stop at about 40 miles per hour.
What happened after the vehicle came to a complete stop?
I approached the vehicle, spoke to the sole occupant of the driver of the vehicle, and told him I was Trooper Ching with Michigan State Police, and requested his driver's license.
Did you see what position that person was inside of the vehicle? Was he operating the vehicle? Do you see the person that was operating that vehicle in the courtroom today?
I do.
Can you tell me where he's sitting and what he's wearing, please?
He's sitting to your right in a green jumpsuit.
Your Honor, may the record reflect the witness identify this defendant?
No objection, Your Honor.
Record shall so reflect.
When you made contact with the defendant and asked him for his driver's license, what happened next?
He told me that he was
Did he say anything to you?
traveling, not driving.
He did.
What did he say to you?
I can't exactly recall what it was that he said, but somewhere early on he advised me that I did not have the right to stop him. And actually, right after I asked for his driver's license, he asked what my reason for the stop was.
What did you say?
I told him that I observed him on my radar. I observed speed on my radar that was over the speed limit.
What happened after you told him that?
I requested his driver's license again.
Did he give it to you?
He did not.
What happened after he didn't give you the driver's license?
He stated that I did not have the right to stop him because he was traveling in a private capacity and not a commercial capacity.
What did you do?
I advised him that he is required to provide a driver's license at the request of a peace officer.
Did he provide you a driver's license?
He did not.
Did you observe anything about the vehicle's license plate?
The vehicle's license plate did not look familiar to me. I had not had a chance to actually run the plate.
Okay. So while you're at the side of the car and you're speaking with him, are you continuing to request his driver's license?
Multiple times.
Is he ever providing it to you?
No.
Is he printing his own license plate?
How long do you think, well, I want to ask that question. As this is going on, what are you doing?
While I'm speaking with him, I requested for back because he's not being very compliant.
You asked for what?
Backup.
Backup? Okay. At some point, did you return back to your vehicle?
I did.
And what did you do when you got back there?
I attempted to run the plate. Did not seem that the plate existed, essentially.
What did you notice about the plate once you were able to examine it?
It was not registered to any specific state.
Do you recall what it said on it?
It's a diplomat on the top, non-expiring on the bottom, and I believe it said non-commercial.
Were you ever able to get any information about the vehicle?
Not on the plate.
How did you get information?
I read the VIN of the vehicle.
Were you able to find current registration for the vehicle when you ran the VIN?
I did not.
Did you request that the defendant continue to provide you his driver's license throughout your interactions with him? Did you ever ask him to get out of the car? When did that happen?
Multiple times.
On my initial contact, after not receiving a driver's license multiple times, I advised him to step out of the car. And after going back to my vehicle, coming back, I advised him he needed to step out of the car. And none of those were followed.
Did you eventually get him out of the car?
Yes.
How?
Taser, taser, taser.
I told him he had one more chance to step out of the vehicle on his own. And he said he was not stepping out of the vehicle. So I pushed his window, which on initial contact window was all the way down. After backup had arrived, I believe sometime after, while I was going back to the car, he cracked the window. I put my hands in the window and I shoved the window down into the car. I reached in, unlocked the door, and unbuckled his seatbelt. At that point, he stepped out of the vehicle and was handcuffed.
And you didn't break the window, you just pushed it down?
It may be damaged.
It
I did not break the
probably
glass.
I should say you didn't shatter it with your stick.
Correct.
Thank you. Thank you for correcting me, Trooper. Were you wearing a body camera on the day that this happened?
Please, yes.
Was it functional and operational?
Yes.
Have you had a chance to review the recordings from that day?
We might get to see
Your Honor,
this.
with permission, the people would like to propose to admit Exhibit 1, which is the body cam, but I'm only going to play select portions of it.
Yes. Is there any objection?
No objection, Your Honor.
All right.
The first segment is about 8 minutes long, Your Honor.
Here we go.
Before playing that, the license plate, did it say, was it black and white? You recall? If you recall.
It was either black or dark blue, white, something along that line.
And it said diplomat across the top.
Correct.
And then at some point at the lower, maybe left, right-hand corner, talked about it being non-expiring or something along those lines.
Yes.
Oh, joy.
May I, Your Honor?
Yes, you may.
Thank you so much.
Oh, joy.
And this is got sound, so I apologize if it's too loud at first. I'll adjust it.
I'll adjust it too. Look at the radar. 75, 75, 69, 75. 78. Motorola, not a sponsor. Looks like we're driving slower and slower. Stop. Stop. The officer's like, just stop. Park already. 40 miles an hour along the side of the road. Okay, here we go.
What's that? My radar, sir. And your driver's license. My radar is out of my vehicle. Where is your driver's license?
can't hear. We just see the tie waving in the wind.
No, it's not matter what capacity or a violation of speed.
Maybe we should FOIA request this.
You don't need traffic stop. By law, you have to identify yourself. Yes, sir. Traffic stop. You are in violation of the law. I stopped you. I'm conducting an investigation of the violation. You must identify yourself. According to Michigan law. Please say violation. It's not commercial. It doesn't matter if you're going to get ice cream at McDonald's. I can stop you for speed. Where is your driver's license? Okay, where is your driver's license? Yes, you do.
He's calling for backup. Mr. Magoo was checking the internet to make sure he said everything he's supposed to say to the police officer, but the officer is not buying it. He said he's a diplomat. He said he's traveling, not driving.
Where's your driver's license?
Step out of the car. That's a clear order.
I'm not calling my supervisor. I'm not having a supervisor down here. They're a long ways away. We're not going to sit here and wait for a supervisor. So.
Ooh, officer, that was wrong.
I understand that. If you cooperate with me, I need your identification to get you out of here. Yes, I do. Oh, and you're required to identify yourself to a police officer. I'm not trying. It does not matter what capacity you're traveling in. It does not matter what capacity you're traveling in. What about the plate? What are the plates supposed to be? I know nothing about that plate means. What's that mean? That means nothing to me. Who are you? I'm Trooper Chief, which is grade 3. So I work with the brand code, my badge number is 1245. Now, if you don't identify yourself, you will identify yourself. Yes, sir. From a radar gun? Yes, sir. It's mounted in my vehicle, according to everybody. You know that state troopers, police officers all around the world, to seek to engage them because they're fighting these guns. Okay, well, I have experienced that, so I feel for those state troopers. Identify yourself. What is your name? You don't want to leave yourself. What is your name? You don't want to leave yourself. Yes, I do. Yes, I do. I am here on the side of the road with you. You need to identify yourself. Yes, you did. That is why I'm stopping you.
Mr. Magoo still won't identify himself.
Why did you roll? For what reasoning? What reason do I have to call my supervisor? Because you don't want to listen to me? If you are not obeying the law? So, identify yourself. Go to the dog test. Let me see the dog test. That's open view. I'm not doing it. Now. Identification now.
Now.
Yes, you have. That's why I'm stopping. Okay. Do you want to say it? You are escalating the situation. You need to identify yourself to me. I'm not going to argue with you anymore. You will step out of this vehicle. Well, identify yourself. I ask you to cooperate with that defense mission you have on the road. It's Trooper Team. I accept that. Badge number 1245. What am I Let's have you call him right now. You're not going to tell us about it.
This is in Michigan.
90 miles an hour on the freeway, it's marked 70.
The cop's losing it. You're going 95 and a 70.
Identify yourself to me.
Why won't you identify yourself to me?
Identify yourself. Take your name. What's your name?
What is your name? He goes back to the car. Probably says some bad words in his car. Another officer has arrived.
And Your Honor, skipping ahead to about the 33-minute mark.
Oh, I wanted to hear what happened in the car. That would have been good. We've got 4 or 5 officers here.
What's up? What's going on? Okay, they criminal? Okay, I'm not worried about that because I'm acting with the law right now. I'm acting with the law. One more chance to step out of the car on your own. You don't get one right now. You don't get one right now. You'll get one before you see a judge.
I want a lawyer.
Yes, you will get one before you see a judge. You have the right to remain silent if that's what you would like before talking until you can talk to a lawyer.
He wants a lawyer on the side of the road.
Step out of the car. That was your last chance. Thank you.
Window down, door unlocked.
Step out of the car. Try and fix people. He said I will keep my phone.
The closest I've ever been to Mr. Magoo. All right.
Trooper Cheney, were you able to eventually ascertain the identity of the driver, the defendant?
I was.
And did you check him in lean?
I did.
What did you discover?
He does not have a valid driver's license in the state of Michigan.
Did he have any warrants at the time that you pulled him over?
He did. To correct myself, he didn't have a valid driver's license at all. That I saw right.
Not at all. Okay, thank you. After you arrested the defendant, what happened next?
I asked him if he had any reason that he needed to go to the hospital for. He advised that he had rapid heartbeat.
Did you go to the hospital?
We went to Chelsea Hospital.
The Trinity Health in Chelsea? Is that right? Or Chelsea Hospital?
Just Chelsea Hospital.
Okay. And after, was he cleared by medical staff and taken to the jail?
After receiving medical assistance at Chelsea Hospital, we went to Washington County Jail.
May I have a moment, Your Honor?
Just so that I'm clear, he told you he had rapid heartbeat. You took him to the hospital. He refused medical treatment.
Correct.
Okay. All right.
Oh, man. Magoo's like, it seemed like a good idea at the time.
Your Honor, I'll pass the witness.
Cross-examination.
Your Honor, before I begin, may I very briefly confirm with opposing counsel?
Okay.
Is there a plea you're willing to offer at this point? Could you, give us something? I mean, I'm trying here. You see what I'm working with. She's like, why would I do that? Nope.
Good afternoon, Trooper. My name is Alex Warren Green. I represent Mr. Magoo in this matter. So, Trooper, this was on July 3rd of this year, right?
Correct.
Day before Independence Day, right?
Correct.
Tons of cars on the road. And this was on I-94 in Scio, right?
Yes.
And that is a 70-mile-an-hour limited access highway or freeway, right?
Yes.
And in your experience as a state trooper, you know that conducting traffic stops on the freeway is dangerous, right?
Yes.
There's high speeds, distracted driving, right? There's large commercial vehicles like tractor trailers, and like you already said, lots of traffic, right?
Yes.
And another reason that it's dangerous is because there's limited space on the shoulder to conduct the traffic stop, right?
Correct.
Trooper, on your direct examination, we saw video from your body-worn camera. In addition to the body-worn camera, you have a dashboard-mounted camera, right?
Yes.
And the dashboard-mounted camera activates when you activate the overhead lights, right?
Correct.
And when you activate it, it captures 30 seconds back in time, right?
Correct.
Okay. And Your Honor, I believe this is by stipulation. I would ask to play a portion of the trooper's dash camera. I'd move to admit it.
It's defense A.
This would be defense A, Your Honor.
Okay, go ahead.
We're getting more video. Defense bringing in the dash cam. Must have something that he said or something on there.
Trooper, can you see that on the screen right in front of you?
Can't see Jack. There it is. Okay. Ooh, nice. 96 miles per hour. Michigan State Police, Officer Colin Cheney. That's everything we need to do a FOIA request. Yep, we can get that from there. Thank you. Appreciate it.
Trooper, I'm just going to pause right there. This is your dashboard mounted camera from July 3rd, right?
Correct.
And there's some writing on the screen, right?
Yes.
Okay.
If it's a 1, that means the trooper is pushing the brakes. Now he's not pushing the brakes. Let's watch for the lights. The lights on the very bottom should go to a 1 when he turns them on, which will happen in about 20 seconds, maybe 15 seconds. Probably a siren at the same time. All right, lights are on.
Trooper, I paused at exactly 30 seconds. This is when you activated your overhead lights, correct?
That should be very close. Yes.
Okay.
Lights are on, no siren yet. It's braking, moving to the shoulder. Cop's braking as well. Still braking. Cop's not braking, they're coasting, now brakes a little bit. There's a shoulder, he needs to safe space. Okay. And we're still cruising along, but we are slowing down just very slowly. I would not say that was a mile. I would not even say that was half a mile. May have been a little bit of a fib.
Pausing the video at 1 minute and 18 seconds. Trooper, you'd agree with me that both you and Mr. Magoo are in a stationary position at this time, right?
Correct.
And Your Honor, I'm going to take down the exhibit at this point. Trooper, after you reach that stationary position, he never put the vehicle back into motion, did he?
No.
Well, at least for the duration of the traffic stop, he didn't put it back into motion, did he?
No, he did not.
Okay. And the patrol vehicle you have, it has a mounted radar system, right? That's mounted on your dashboard.
Yes.
And that radar system, you can obtain a printed document that tells you the readout obtained at a particular time. Is that right?
I'm not aware if I'm able to do that. I've never been taught how to do that or seen any of that.
So from your mounted radar, you have never obtained a printed document suitable for court. Is that your testimony?
Yes.
So
I'm not aware if it is possible or not. I just have never done it and do not know how to.
understood. Thank you, Trooper. You followed Mr. Magoo's vehicle for a period of time before activating your lights, right?
Yes.
And once you did activate your lights, he did in fact decelerate, right?
Yes.
And shortly after that, he moved over to the shoulder of the road, right?
Yes.
And then you following Mr. Magoo went over an overpass, right?
Yes.
And that overpass has metal barriers on either side of it, right?
Yes.
And after you get to the end of the overpass bridge, that's when he brought the car to a stop, very shortly after you got to the other side of the bridge, right?
I wouldn't necessarily agree.
Well, Trooper, you'd agree with me that the entire time after you turned your lights on, following Mr. Magoo was under a minute, right?
Yes. With my lights on behind it, yes.
And on something like an overpass, there's even less space to conduct your traffic stop, right?
Typically, yes.
Because of the metal barriers, if something were to happen, you can't just jump into the ditch or the grass, right?
Yes.
So after you're stationary, Mr. Magoo's stationary, you walk up to the window, right?
Yes.
And you two have a discussion, right?
Yes.
And Mr. Magoo didn't hit the gas pedal, did he?
No.
He didn't open the door and start running down the freeway, did he?
No.
He didn't take a swing on you or any other officers that responded, did he?
No.
He didn't reach for anything on your utility belt, right? Your Honor, if I may have one moment. Thank you.
If the best we have is he didn't flee.
The reason for this traffic stop wasn't because of a license plate, was it?
Not at the time.
And the reason for initiating the traffic stop wasn't because of an invalid or expired license, was it? It was for speed, right?
Yes.
So at the time you initiated this traffic stop, you hadn't witnessed any crime occur in your presence. Would you agree with me?
Speed violation, I did not.
Okay. Thank you for answering my questions, Your Honor. I have nothing further at this time.
Any redirect?
Trooper Cheney, if you recall, what did the defendant tell you he was doing when he was driving on the shoulder and not pulling over and stopping for you?
He advised he was emailing his summons for a trial that he has against prosecutors and magistrates.
Thank you. Nothing further.
Your Honor, very briefly on that.
Yeah, go ahead. That opened up a whole bunch of stuff. Go on.
Thank you, Your Honor. Trooper, on behalf of Mr. Magoo, after you saw this plate, you didn't call the embassy, did you? You didn't call the Department of Transportation, did you?
No.
All right. Your Honor, I have nothing further at this time.
No redirect. Thank you, Your Honor.
Mr. Magoo wants me to ask this question.
Trooper, you may step down. Thank you, sir.
Did you call the embassy?
It's witnesses.
Did you call
Your
Magoo
Honor,
Land?
will move to add count 6, assaulting, resisting, or obstructing a police officer for Trooper Colin. And I have no additional, contrary to 75081D1, I have no additional witnesses at this time.
He said he was emailing a
The defense
summons.
calls no witnesses, Your Honor.
All right. And
for a case against
response to
prosecutor.
Their motion to bind.
That's why he didn't stop so fast.
Thank you, Your Honor. The defense would object to bind over in this particular case. Your Honor, the court has seen the video. We are asking the court to consider the evidence here. Our position is that it is insufficient even at a probable cause standard. The video, the dash camera specifically showed that after the troopers' overhead lights went on, Mr. Magoo did make an effort to decelerate. He moved over. After they went across the overpass bridge, he did bring his car to a stop. Your Honor, he didn't need to be physically extracted from that vehicle. He did get out. He got arrested without incident. For the record, Your Honor, we would be objecting to bind over.
It's a good effort, Mr. Attorney.
Go ahead.
Your Honor, I do believe we have laid more than sufficient evidence to sustain both felony counts that have been presented today. Furthermore, Your Honor, the people will note the extreme restraint that the trooper showed while dealing with the defendant and not escalating the situation, continuing to try to resolve it as peacefully as possible. I think the court saw in People's 1, the 33 mark where the court could clearly see Lieutenant Kratzenberg, and there were 2 other officers from Chelsea PD as well as an additional trooper who had all come to the scene to help. I do believe we have presented sufficient evidence for at least what we have, and I do think there's an argument that there's more than one resisting and obstructing based on what's been presented today for the 2 different interactions that were shown, but I've added the 1. I have nothing further. Thank you, Your Honor.
Court, after hearing the testimony in the case, would agree with the people that there's sufficient evidence to show that the defendant committed the offense of fleeing and eluding 4th degree. And I think it should be clear that the driver's obligation is to hold their vehicle over when those overheads go on behind them. He did not really do that. Prior to getting what's left out of the defendant's argument is he's traveling quite a ways prior to him even getting to that overpass. There are other places, if the argument's being made, that he couldn't have safely pulled over. When you truly look at it, there are other places that he could have pulled over, could have done so safely. And anybody that's seen a vehicle pulled over, yes, the trooper actually, or the officers actually put themselves and their vehicle more at risk because of the way that they line their vehicle up when pulling a vehicle over. So that vehicle could have stopped well before, quite frankly, the overpass, and well before the time that it did. So I don't find that argument very persuasive. And would indicate that the people have sustained a burden regarding the 4th degree fleeing and eluding. Also, just noted, the trooper, his voice is telling him, and it was in People's Exhibit 1, he's sure he knows that Mr. Magoo can't hear him, or whoever's in that vehicle can't hear him, but he is saying, pull over. He's trying to implore that vehicle to pull over. So the court will bind the defendant over on count 1. With reference to the added count 6, the resisting and obstructing.
I don't think you should get this one.
I
Resisting,
think it goes
yes.
without
obstructing
being said that the restraint that this trooper showed was amazing. Probably one of the reasons I'm not a police officer. I don't think I could have showed that much restraint on the side of that road. Face. That it seemed like forever before that door opened. The officer, the trooper, would have certainly been well within his rights to have acted, opened that door at some point in time. What was actually phenomenal is that he did not do that, that he left. He was not looking to indeed escalate it anymore. And it was just amazing to me. And only when it came down to the point that something indeed had to be done did the trooper take action.
It's amazing he didn't drag him right out the window.
Quite frankly, that behavior is Well, I've always told people around the country, with all due respect to other state troopers and all of the places I've been, I think Michigan has the best. So, and I mean that from the bottom of my heart. What he did was just amazing because a lot of people, as the defense was pointing out, a holiday time of travel, a lot of people were put in jeopardy, not by what the trooper did in pulling the vehicle over, not by the manner in which he pulled it over, but by, quite frankly, Mr. Magoo's obstinance in not answering the trooper and not complying with the order of the trooper. There are probably, and I think the people are right, that there's probably more than one resisting and obstructing here. Since the people aren't asking, I won't add an additional or 2 counts, or at least, of resisting and obstructing. I will only add 1 of resisting and obstructing as an added count 6. So defendant, so the record is clear, is bound over to stand trial on counts 1 and 6, those being felony, with counts 2, 3.
Magoo's shaking his head.
2, 3, and 4 and 5 following is misdemeanors.
Your Honor, with respect to the Circuit Court of Raymond, we acknowledge receipt of the information, waive its reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all 6 counts. Pre-trial in this matter will be
October 9th at 1:30 with Judge Slay.
October 9th, 2025.
Judge Slay.
1:30. Judge Slay.
Your Honor, I can have an amended information over by about noon tomorrow, adding that count 6, and of course we don't have them prepared right now.
That's fine.
Thank you, Your Honor.
Put that up there.
I think I know what Mr. Magoo's
will
thinking.
Continue. Thank you.
I think he's saying,
Mr. Magoo, I'll come see you tomorrow.
Magoo's thinking, I could have done better on my own. Could have
When
done
I
better.
go off, I'm in recess. I'm going to tell you right now. I'm in recess. Hurry up, take me off. Am I good?
Yeah.
Okay.
So want to hear what's going on right now. I'm in recess. He says, take me off, take me off. I need to say something. Oh, man. All right. With that, we finally reached the end of the day. Judge Slay. Do we have access to Judge Slay? Have to do some digging. I think she does stream hers. Or at least some of them. Yeah. How'd he end up in jail? Well, pretty much he ran his mouth. That's probably how it happened. Judge Slay has very little patience for soft sits. The lawyer is pretty good. He did a good job. Much better, I think. Oh, we did get to 1,000 likes, and thank you, AWOL, for the gifting the 5 memberships as a celebratory measure. Thank you very much. What a long day. It has been a long day. Thank you to our amazing moderators, and thank you to all of you who have been here and stayed with us throughout the trial today. We are expecting that possibly as soon as tomorrow, we pivot to the Donna Adelson trial. And when we do, it's going to get crazy. It's going to get nuts. It's 3 wild cases in a row. I think we're almost done with this Georgia case. I think tomorrow might be the last day for the state. So anyway, I'm going to finish my dinner, which is delicious. Thank you to my son who made it. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe. Till we go live tomorrow morning. We'll be court hopping tomorrow morning. So we're gonna be watching some things because the court in Georgia will not start till about lunchtime. They're gonna bring people in and send them to the lunch, so it'll be crazy. All right, Bug Dugger, thank you as well. Gifted 5 memberships. Thank you all. Thanks to all the new subscribers who joined today. It's wonderful to have you. Great to have friends from Broken Baker and beyond. You guys have a good night. Be good to each other. We'll see you. Bye.
stupid guy.